नमस्कार विद्यार्थी मित्रांनो, आजच्या या सेशनमध्ये मी तुमचं स्वागत करतो. आपण या ठिकाणी आपली जी नुकतीच टेस्ट झाली होती पॉलिटीची टेस्ट, त्या पॉलिटीच्या टेस्टच्या अनुषंगाने डिस्कशन सेशन आपण आयोजित केलेलं आहे. ओके, वन बाय वन आपण सगळ्या प्रश्नांची सविस्तर चर्चा आपल्याला करायची आहे. वी आर गोइंग टू डिस्कस ऑल द क्वेश्चन्स अँड द नुआन्सेस असोसिएटेड विथ दोज क्वेश्चन्स. पहिला क्वेश्चन लक्षात घ्या. कन्सिडर द फॉलोइंग स्टेटमेंट्स रिगार्डिंग पब्लिक इंटरेस्ट लिटिगेशन PIL. ओके, the disputes between the two erring groups purely in the realm of the private law would not be allowed to be agitated as a PIL. बरोबर आहे की नाही? लक्षात घ्या. PIL चा ऑब्जेक्टिव्ह काय असतं? एक लार्जर पब्लिक गोल, पब्लिक इंटरेस्ट त्या ठिकाणी सर्व झाला पाहिजे. पण ज्या ठिकाणी जेव्हा हा संघर्ष इन द रियाम ऑफ द प्रायव्हेट लॉ म्हणजे खाजगी स्वरूपाचा असेल, त्या ठिकाणी PIL चा काहीही संबंध नाहीये. त्याच्यामुळे हे विधान बरोबर आहे. ओके, लक्षात घ्या. द सर्व्हिस मॅटर्स अँड दोज पर्टेनिंग टू द पेन्शन अँड ग्रॅच्युटी मॅटर्स कॅन बी सेटल्ड थ्रू द PIL. हे विधान मात्र चुकीचं, लक्षात घ्या. ओके, ते तुम्ही बघा या ठिकाणी PIL च्या नियमांमध्ये सुप्रीम कोर्टाने जे काही निर्णय दिलेले आहेत त्यानुसार असं सांगितलं जातं की केसेस फॉलिंग अंडर फॉलोइंग कॅटेगरीज विल नॉट बी entertained as the PIL and these may be returned to the petitioners. त्याच्यामध्ये काय सांगितलंय? लँडलॉर्ड टेनंट मॅटर्स आणि सर्व्हिस मॅटर्स अँड दोज पर्टेनिंग टू पेन्शन अँड ग्रॅच्युटी, आणि त्याचबरोबर ऍडमिशन टू मेडिकल अँड अदर एज्युकेशन इन्स्टिट्यूशन्स, पिटिशन्स फॉर अर्ली हिअरिंग ऑफ द केसेस पेंडिंग इन द हाय कोर्ट अँड द सबऑर्डिनेट कोर्ट. या सगळ्या गोष्टींना PIL मध्ये घेतलं जात नाही. त्याच्यामुळे दुसरं स्टेटमेंट हे चुकीचं आहे. मग काय घेतलं जातं? द बॉन्डेड लेबर मॅटर्स, नेग्लेक्टेड चिल्ड्रन, नॉन पेमेंट ऑफ मिनिमम वेजेस, petitions against police for refusing to register a case, petitions against atrocities on women, petitions complaining of harassment or torture of person belonging to scheduled caste, scheduled tribes and economically backward classes, petitions pertaining to environmental pollution and petitions from rat victims and family pension issues. या सगळ्या गोष्टींना PIL म्हणून एंटरटेन केलं जातं, हे लक्षात घ्या. आणि म्हणून या ठिकाणी दुसरं स्टेटमेंट चुकीचं आहे. टू अवॉइड मिसयूज ऑफ द PIL, court should be fully satisfied that substantial public interest involved before entertaining the petition. Okay, that statement is also correct. म्हणून 1 आणि 3 ही विधानं बरोबर आहेत. चला, ओके, पुढचा क्वेश्चन बघा या ठिकाणी. नेक्स्ट क्वेश्चन इज कन्सिडर द फॉलोइंग स्टेटमेंट विथ रेफरन्स टू द हाय कोर्ट्स. ओके, लक्षात घ्या. इट कॅन विड्रॉ अ केस पेंडिंग इन द सबऑर्डिनेट कोर्ट इफ इट इन्व्हॉल्व्स द सबस्टॅन्शियल क्वेश्चन ऑफ द लॉ दॅट रिक्वायर इंटरप्रिटेशन ऑफ द कॉन्स्टिट्यूशन. येस, आता लक्षात घ्या. हायकोर्ट काय करू शकतं? सबऑर्डिनेट कोर्ट मधले काय म्हणू आपण त्याला, की सबऑर्डिनेट कोर्टचा पार्ट असणारा एखादं प्रकरण जे सध्या सबऑर्डिनेट कोर्टमध्ये आहे, ओके, निम्न स्तरावरच्या कनिष्ठ स्तरावरच्या न्यायालयांमध्ये आहे, आणि त्या प्रकरणामध्ये समजा कायद्याचा अर्थ लावायचा असेल, किंवा काय म्हणू आपण त्याला कायद्याचा अर्थ लावायचा असेल, किंवा आपल्या संविधानाचा एक नव्याने अर्थ लावायचा असेल, असं जर दिसतं तर लक्षात घ्या, त्या केसमध्ये काय होईल? त्या केसमध्ये जो कनिष्ठ न्यायालय कदाचित त्या गोष्टी तेवढ्या एफिशियंटली करता येणार नाही कनिष्ठ न्यायालयाला. हा विचार करून ओके हायकोर्ट काय करू शकतं की कनिष्ठ न्यायालयाकडून ते प्रकरण आपल्याकडे हस्तांतरित करू शकतं. म्हणून पहिलं विधान बरोबर आहे. हायकोर्ट कॅन एक्झामाइन द कॉन्स्टिट्युशनॅलिटी ऑफ लेजिस्लेटिव्ह इनॅक्टमेंट ऑफ द स्टेट ओनली. बघा या ठिकाणी काय सांगितलं? 42nd अमेंडमेंट ऍक्ट 1976 limited the High Court's judicial review power. It provided that the High Courts it prohibited the High Courts from considering the constitutionality of any central law. आता लक्षात घ्या, हे विधान जर बघितलं तर या केसमध्ये आपल्याला काय दिसेल? हे विधान बरोबर दिसेल. पण द 43rd अमेंडमेंट ऍक्ट ऑफ 1977 हाऊ रिस्टोर्ड द ओरिजिनल पोझिशन. आणि मग जेव्हा आपण ह्या गोष्टीचा विचार करू तेव्हा हे स्टेटमेंट आपल्याला चूक झालेलं आहे असं दिसतं. सो सेकंड स्टेटमेंट इज रॉंग. The writ jurisdiction of High Court can be excluded by way of an amendment to the Constitution. मग आता हे स्पष्टीकरण बघा. The jurisdiction conferred on the Supreme Court as well as on the High Court, is part of inviolable basic structure of the Constitution, and hence it cannot be ousted or excluded even by way of an amendment to the Constitution. The case is 1997 L. Chandrakumar versus Union of India. आणि म्हणून लक्षात घ्या, हे विधान सुद्धा आता चूक जातं. ऑप्शन नंबर बी 1 ओनली इज करेक्ट. ओके, then next question is which of the following employees or officers are not covered under the jurisdiction of the central administrative tribunals? Options are officers and servants of the Supreme Court, the secretaries, staff of the parliament, the members of the defense forces, civilian employees of the defense forces. Okay, बघा या ठिकाणी The Central Administrative Tribunal had been established under Article 323A of the Constitution for adjudication of disputes and complaints with respect to recruitment and conditions of service of persons appointed to the public services and the post in connection with the affairs of the union or other authorities under the control of the government. Okay, तर हे वाक्य या ठिकाणी लक्षात घ्या. मग आता ऑफिसर सर्वंट्स ऑफ द सुप्रीम कोर्ट, सेक्रेटरीज अँड स्टाफ ऑफ द पार्लमेंट आणि मेंबर्स ऑफ द डिफेन्स फोर्सेस आपल्याला काय दिसतात, हे या कंडिशन मध्ये फुलफिल नाहीत. ओके, दे आर अपॉइंटेड टू पब्लिक सर्व्हिस पोस्ट इन कनेक्शन विथ अफेअर्स ऑफ द युनियन ऑर अथॉरिटीज अंडर द कंट्रोल ऑफ द गव्हर्नमेंट. इट इज नॉट द केस, कारण पहिल्या केसमध्ये सुप्रीम कोर्ट स्वतः चीफ जस्टिस, सेक्रेटरी स्टाफ ऑफ द पार्लमेंट, इट इज व्हॉट वी कॅन से द पार्लमेंटची स्वतःची त्या ठिकाणी अधिकारी यंत्रणा असते. ओके, आपण लोकसभेचे सभापती, ओके, हे त्याचे प्रमुख असतात असं आपण म्हणतो. आणि मेंबर्स ऑफ द डिफेन्स फोर्सेस, ओके, दॅट इज ऑल्सो नॉट द केस. आणि म्हणून 1, 2, 3 हे येत नाहीत. बट सिव्हिलियन एम्प्लॉईज ऑफ द डिफेन्स सर्व्हिसेस, दोज आर पार्ट ऑफ द, ओके, युनियन, अफेअर्स ऑफ द युनियन, अँड देअरफॉर ऑप्शन 1, 2, 3 इज द राईट वन. ओके, नेक्स्ट क्वेश्चन. पुढचा क्वेश्चन घ्या. कन्सिडर द फॉलोइंग स्टेटमेंट रिगार्डिंग स्टेट पब्लिक सर्व्हिस कमिशन. 1/2 ऑफ द मेंबर ऑफ द कमिशन शुड बी पर्सन फ्रॉम द SCs अँड द, ओके, SCs. असं आहे का? SC, ST अँड OBC असं आहे का? इथं काय दिलंय? 1/2 ऑफ द मेंबर्स मस्ट हॅव हेल्ड ऑफिस फॉर ॲटलिस्ट 10 years आयदर अंडर गव्हर्नमेंट ऑफ इंडिया और गव्हर्नमेंट ऑफ अ स्टेट. या ठिकाणी कुठल्या ना कुठल्या शासकीय नोकरीमध्ये असावं असं सांगितलेलं आहे. या ठिकाणी SC, ST, OBC चा कुठलाही संदर्भ नाहीये, म्हणून हे पहिलं विधान चूक गेलं. इन केस ऑफ मिसबिहेवियर द प्रेसिडेंट हॅज टू रेफर द मॅटर टू द हायकोर्ट. नाही. ओके, लक्षात घ्या, सुप्रीम कोर्टाला मॅटर रेफर केला पाहिजे. द मेंबर्स ऑफ द SPSC कॅन बी रिमूव्ड बाय द गव्हर्नर. असं आहे का? नाही, बाय द प्रेसिडेंट ऑफ द रिस्पेक्टिव्ह स्टेट. म्हणून हे विधान चूक, हे विधान चूक, हे विधान चूक, तीनही विधान चूक. तुम्हाला इथं इनकरेक्ट विधान विचारलेलं आहे. चला, ॲज द चीफ लॉ ऑफिसर, ओके, लक्षात घ्या, ॲज द चीफ लॉ ऑफिसर ऑफ द गव्हर्नमेंट इन द स्टेट, द ड्युटीज ऑफ द ॲडव्होकेट जनरल इन्क्लूड टू गिव्ह ॲडवाइस टू द गव्हर्नमेंट ऑफ अ स्टेट, ओके, अपॉन लिगल मॅटर्स विच आर रेफर्ड टू हिम बाय द गव्हर्नर. दॅट इज करेक्ट. त्याचं कामच आहे तो, म्हणजे गव्हर्नमेंटला रिप्रेझेंट करणं आणि लिगल मॅटर्सचा सल्ला देणं, हे ॲडव्होकेट जनरलचं काम आहे. दिस इज द ड्युटी ऑफ द ॲडव्होकेट जनरल. To mediate in a dispute between center and state in order to bring about an agreement or reconciliation. That is wrong. That is not job. Okay, हे फेडरल कक्षेमध्ये येतं, लक्षात घ्या. ओके, आणि या संदर्भामध्ये, ओके, at max the governor, advocate general can give advice to the state government, but that does not mean that advice amounts to the mediation in the dispute. Okay, that is not the case. आणि म्हणून लक्षात घ्या, हे विधान चूक आहे. To perform such other duties of a legal character that are assigned to him by the governor. Yes, governor ने जे सांगितलं ते करायचं. Okay, and here governor means the will of the state government itself. To give advice to the governor to make rules for smooth transaction of business in judicial bodies of the state. Okay, that is also not there. Okay, हे बघितलं की लक्षात येतं की अशा काही तरतुदी नाहीये. So 1 and 3, option number C. With reference to Lokpal and Lokayukta Act 2013, consider the following statement. Lokpal consists of a chairperson with a maximum of 8 members, of which 50% are to be judicial members. Okay. त्यानंतर Lokpal conferred with the power to grant sanction for prosecution of public servants in place of the government. 50% of the members of the Lokpal are from amongst SCs, STs and OBCs, minorities and the women. It contains provision for adequate funds to CBI for investigating cases referred to the Lokpal. बघा इथे Lokpal Act काय सांगतो? Chapter 2 of the Lokpal Act, it speaks of the establishment of Lokpal. On and from the commencement of this act, there shall be, okay, for the purpose of this act, a body called Lokpal. The Lokpal shall consist of chairperson who is or has been the Chief Justice of India or has been a judge of the Supreme Court or an eminent person who fulfills eligibility, okay, required eligibility. Such number of members not exceeding 8, out of whom 50% shall be judicial members, provided that not less than 50% of the members of the Lokpal shall be from amongst the persons belonging to scheduled caste, scheduled tribes, other backward classes, minorities and the women. Okay, तर लक्षात घ्या. ओके, या ठिकाणी या सगळ्या तरतुदी या ठिकाणी फुलफिल होताना आपल्याला दिसून येतात, लक्षात घ्या. Okay, so it is conferred with the power to grant sanction of prosecution of public servants in place of the government, and there is a provision for adequate funds because CBI helps Lokpal to consider the matter. Okay, and therefore option D is the correct one. Okay, हा मुद्दा लक्षात घ्या. त्यानंतर 7 नंबरचा क्वेश्चन आहे. Consider the following statements regarding the district planning committee. District planning committeeचे फंक्शन्स काय आहेत? ओके, लक्षात घ्या. याच्याबद्दल या ठिकाणी प्रश्न तुम्हाला विचारलेला आहे. Okay, what are the functions? Okay, or what you can say the provisions regarding the district planning committee. या ठिकाणी बघा पहिला मुद्दा काय दिलेला आहे. ओके, तर पहिला मुद्दा, इट इज मॅन्डेटरी फॉर एव्हरी स्टेट टू कॉन्स्टिट्यूट अ डिस्ट्रिक्ट प्लॅनिंग कमिटी. देअर शॅल बी डिस्ट्रिक्ट प्लॅनिंग कमिटी फॉर एव्हरी स्टेट असं दिलेलं आहे. सो पहिलं बरोबर आहे. गव्हर्नर मे मेक प्रोव्हिजन विथ रिस्पेक्ट टू मॅनर ऑफ इलेक्शन ऑफ मेंबर्स ऑफ सच कमिटी. नो, it is the job of the state legislature and therefore the second statement is incorrect. Okay, all members of district planning committee are elected only by elected members of the district panchayat and municipality. That is wrong. 4/5, not all, and therefore दुसरा आणि तिसरा स्टेटमेंट आपल्याला काय दिसेल, चूक दिसतं. The second and third statement are incorrect and you have been asked to select the incorrect statement. Option number B is the answer. Okay, in the context of elections, which of the following is are not correct regarding the model code of conduct? The election commission first effectively put to use the model code of conduct in 1951. It is a set of guidelines formulated by the Supreme Court in consultation with the election commission. It comes immediately into effect after the election commission issues notification for filing the nomination of the candidates. Okay, तुम्हाला काय विचारलं आहे? Not correct, incorrect statement विचारलेले आहेत. Consider this explanation. As per the ECI, Election Commission of India, the MCC was first observed during 1960. पहिलं statement wrong गेलं. Historically, the credit of giving idea of a model code of conduct for political parties should go to the state of Kerala, that adopted for the first time a code of conduct for the observance of political parties during the general election to the state legislative assembly in the February 1960, says the ECI manual. ECI manual नुसार ही माहिती आहे. According to the ECI, the model code of conduct remains in place during the election in respect of the political parties and candidates, which remains in force from the date of elections are announced, okay, by the commission till the completion of the elections. म्हणजे इथं आपल्याला काय दिसतं, सेकंड स्टेटमेंट सुद्धा रॉंग आहे, हे सुद्धा रॉंग आहे. And it is not Supreme Court, rather it is Election Commission itself with the help of political parties. आणि त्याच्यामुळं मग लक्षात घ्या, all the statements are incorrect. Option D is the answer. Okay, 73rd Constitutional Amendment Act, okay, of 1992 provides a mandatory reservation for, okay, to which of the following? Scheduled caste, yes, it is there. Okay, scheduled tribes, it is also there. Women, but as far as the other backward classes are concerned, okay, it is not by this Constitutional Amendment Act. Rather, it was a responsibility, or this particular task was entrusted with the legislature of the state. म्हणजे राज्य विधिमंडळाला लक्षात घे ही जबाबदारी सोपवण्यात आलेली आहे की जर अदर बॅकवर्ड क्लासेसला जर त्या ठिकाणी काही रिझर्वेशनची तरतुदी करायची असतील तर दॅट कॅन बी डन बाय द लेजिस्लेचर ऑफ द कन्सर्न स्टेट. आणि म्हणून आपल्याला काय दिसतं, ओके, या ठिकाणी तुम्हाला काय विचारलेलं आहे की कॉन्स्टिट्यूशन अमेंडमेंटने कोणाला प्रोव्हाइड केलेलं आहे, तर कॉन्स्टिट्यूशन अमेंडमेंट मी या 3 घटकांना प्रोव्हाइड केलेलं आहे. ॲज फार ॲज दिस 4th OBCs आर कन्सर्न, इट इज द टास्क एंट्रस्टेड विथ द लेजिस्लेचर ऑफ द स्टेट. आणि म्हणून 1, 2, 3 हे त्याचं उत्तर आहे. पुढचा क्वेश्चन घ्या. पुढचा क्वेश्चन काय आहे, which of the following takes decision regarding reservation of constituencies for scheduled caste or scheduled tribes in a particular state? Okay, simple आहे, delimitation commission. What is delimitation here? Delimitation म्हणजे काय? It is an act of redrawing the boundaries of Lok Sabha and state assembly seats to reflect the demographic changes. म्हणून आपल्याला काय दिसतं, प्रत्येक सेन्सस नंतर डिलिमिटेशन कमिशन येतं आणि लोकसंख्येच्या संरचनेमध्ये डेमोग्राफीमध्ये काय चेंजेस झालेले आहेत त्यानुसार मग ते चेंजेस आपल्याला इलेक्शन्स मध्ये रिफ्लेक्ट व्हावेत. ओके, या मागचा त्याचा हेतू असतो. ओके, त्यासाठी कॉन्स्टिट्यूशन प्रोव्हिजन्स कोणत्या आहेत? आर्टिकल 82 स्टेट्स दॅट आफ्टर ईच सेन्सस द पार्लमेंट पासेस द डिलिमिटेशन ऍक्ट. बघा, आर्टिकल 170 स्टेट्स दॅट आफ्टर ईच सेन्सस स्टेट आर डिवायडेड इंटू टेरिटोरियल कॉन्स्टिट्युएन्सीज बेस्ड ऑन द डिलिमिटेशन ऍक्ट. सो 82 and 170 लक्षात ठेवा. As far as the functions of the delimitation commission are concerned, okay, it determines the boundaries to select the number of constituencies and their boundaries so that population of all the constituencies are nearly equal. हे लक्षात घ्या. हेतू काय आहे की कॉन्स्टिट्युएन्सी, प्रत्येक कॉन्स्टिट्युएन्सी पॉप्युलेशन ही इक्वल असली पाहिजे, हा त्याच्या मागचा हेतू असतो. म्हणून एक लक्षात घ्या की प्रत्येक कॉन्स्टिट्युएन्सी ही त्या जिल्ह्यापुरतीच बरेच असते असं नाही, बऱ्याच जिल्ह्याच्या बॉर्डर क्रॉस करून इतर जिल्ह्यांचं देखील, म्हणजे 2 किंवा अधिक जिल्ह्यांमध्ये एखादी कॉन्स्टिट्युएन्सी असू शकते. Allocation of seats to ST and SC. The commission also determines whether seats should be allocated for scheduled caste and scheduled tribes groups in place where their populations are large as per Article 330, 332. म्हणून या ठिकाणी ऑप्शन नंबर ए इज द करेक्ट वन. ओके, नेक्स्ट क्वेश्चन पटकन घ्या पुढचा. Which of the following are sources of revenue for the municipal bodies? ओके, यस, या ठिकाणी हे सगळे सोर्सेस लक्षात घ्या. इफ यू लुक इन टू द ओके द सोर्सेस ऑफ द रेव्हेन्यूज, ओके, द प्रोफेशनल टॅक्स, टोल चार्जेस ऑन द न्यू ब्रिजेस, सेवरेज चार्ज अँड एज्युकेशन सेसेस. या ठिकाणी आपल्याला काय दिसतं की देर आर certain, what we can say, certain sources which are in the form of the grant from the state government. But at the same time, in certain cases, काही विशिष्ट बाबतींमध्ये म्युनिसिपल बॉडीज जे असतात लक्षात घ्या, त्यांना वेगळ्या प्रकारची शुल्क आणि टॅक्स वसूल करण्याची देखील परवानगी दिली असते. आणि या यादीमध्ये या चारही घटकांचा समावेश करण्यात आलेला आहे. पुढचा क्वेश्चन बघा. कन्सिडर द फॉलोइंग स्टेटमेंट्स अबाउट द सर्व्हिस वोटर्स. It has been defined in the Representation of the People's Act 1950. Yes, these voters comprise of the central civil servants posted in other Indian states. Okay, they cast their vote via proxy voter and postal ballots. Okay, या ठिकाणी तुम्हाला करेक्ट स्टेटमेंट कोणते ते विचारलेलं आहे. सो कन्सिडर दिस पर्टिक्युलर एक्सप्लेनेशनचा विचार करा. सर्व्हिस वोटर इज अ वोटर हॅव्हिंग सर्व्हिस क्वालिफिकेशन. सर्व्हिस क्वालिफिकेशन ज्याच्याकडे आहे तो सर्व्हिस वोटर. ही डेफिनेशन लक्षात घ्या. Who is a service voter? Who possesses the service qualification. So what is service qualification? According to the provision of subsection 8 of the section 20 of the Representation of the People Act 1950, पहिलं विधान बरोबर गेलं. What is service qualification? Service qualification means being a member of the armed forces of the Union, being member of the force to which provisions of the Army Act 1950 have been made applicable. Okay, being a member of an armed force of a state and serving outside that state, being a person who is employed under the government of India in a post outside India. Okay, लक्षात घ्या. याच्यामध्ये कुठेतरी हे सेकंड स्टेटमेंट बसतं का? कंपराइज ऑफ द सेंट्रल सिव्हिल सर्वंट पोस्टेड इन अदर इंडियन स्टेट्स. नो. ओके, काय लक्षात घ्या, ह्या स्टेटमेंटला तसं बघितलं तर काही मिनिंगच येत नाही आणि त्याच्यामुळे 1 and 3 ओके इज द राईट आन्सर. ओके, नेक्स्ट क्वेश्चन घ्या. कन्सिडर द फॉलोइंग स्टेटमेंट विथ रिस्पेक्ट टू सेंट्रल इन्फॉर्मेशन कमिशन. द कमिशन एंटरटेन्स कंप्लेंट्स. ओके, the Commission entertains complaints relating to the public financial institutions and public sector undertakings. It provided that the salary allowances of the Chief Commissioner, such as prescribed by the state, as such are prescribed by the central government. Okay, CIC, the Commission entertains complaints relating to the public financial institutions and public sector undertakings. It is correct statement. The provided that it is provided salary allowances of the Chief Information Commissioner such as prescribed by the central government. Okay, बघा या ठिकाणी काय सांगितलेलं आहे. राईट टू इन्फॉर्मेशन मीन्स राईट टू इन्फॉर्मेशन accessible under the act which is held by or under the control of any public authority. Any public authority. Okay, लक्षात घ्या. Okay, their statement first becomes the correct, and it includes the right to inspection of work, document, records, etc., taking notes, extracts or certified copies of documents or records, taking certified samples of the material, obtaining information in the form of diskettes, floppies, tapes, video cassettes, or any other electronic mode, or through printouts, where such information is stored in a computer or any other device. Okay, ही simple definition लक्षात घ्या. पहिला आणि दुसरा दोन्ही स्टेटमेंट या ठिकाणी बरोबर आहे. ओके, नेक्स्ट क्वेश्चन. ओके, येस, 14 नंबरचा क्वेश्चन. Consider the following statements regarding the subordinate courts. Subordinate courts work directly under the supervision of Supreme Court. No, High Court. त्याच्यामुळे पहिलं विधान चूक. Parliament can give jurisdiction to the subordinate court. बघूया ते स्टेटमेंट काय आहे. The appointment of the person other than district judge to judicial service of a state are made by the governor of the state after consultation only with the High Court. इथं असं आहे का? नो. इथं काय दिलेलं आहे? ओनली असा शब्द वापरला आहे आणि ओनली हायकोर्ट नाही, तर स्टेट पब्लिक सर्व्हिस कमिशन अँड हायकोर्ट असं आहे आणि त्याच्यामुळे हे स्टेटमेंट सुद्धा चूक आहे. आता बघू व्हॉट अबाउट सेकंड स्टेटमेंट. ओके, या ठिकाणी काय दिलेलं आहे? विदाउट प्रिज्युडाइज टू द पॉवर्स कन्फर्ड, लक्षात घ्या, विदाउट प्रिज्युडाइज टू द पॉवर्स कन्फर्ड ऑन द सुप्रीम कोर्ट, पार्लमेंट मे बाय लॉ एम्पॉवर एनी अदर कोर्ट म्हणजे इथं लोकल कोर्ट सुद्धा आलं, सबऑर्डिनेट कोर्ट सुद्धा आलं, लक्षात घ्या. To exercise within the local limits of his jurisdiction all or any of the powers exercisable by the Supreme Court. त्याच्यामुळे सेकंड स्टेटमेंट बरोबर येतं. आर्टिकल 234 provides for the recruitment of persons other than district judges to the judicial service. Appointment of persons other than the district judges to the judicial service of a state shall be made by the governor of the state in accordance with the rules made by him in that behalf after consultation with the SPSC and the High Court exercise jurisdiction with respect to that state. आणि म्हणून पहिलं आणि तिसरं स्टेटमेंट चूक, दुसरं स्टेटमेंट बरोबर आहे. ओके, येस, हे लक्षात घ्या. ओके, विथ रेफरन्स टू एक्झिक्युटिव्ह पॉवर्स ऑफ द गव्हर्नर, विच ऑफ द फॉलोइंग स्टेटमेंट्स आर करेक्ट? He appoints the state election commissioner and determines his conditions of service and tenure of the office. Okay, yes, बघूयात आपण या ठिकाणी. विथ रेफरन्स टू एक्झिक्युटिव्ह पॉवर्स ऑफ द गव्हर्नर विच ऑफ द फॉलोइंग आर करेक्ट. करेक्ट विचारलेलं आहे, बरोबर आहे. ही अपॉइंट्स ट्रायबल वेलफेअर मिनिस्टर इन स्टेट ऑफ द छत्तीसगड. ओके, देन अपॉइंट चान्सलर ऑफ युनिव्हर्सिटीज इन द स्टेट. चान्सलर का व्हाईस चान्सलर असतं? व्हाईस चान्सलर. आणि त्याच्यामुळे हे स्टेटमेंट चूक झालं, लक्षात घ्या. मिनिस्टर्स होल्ड ऑफिस ड्युरिंग द गव्हर्नर्स प्लेजर. हे वाक्य तर पूर्णपणे बरोबर आहे. The chief minister shall be appointed by the governor and the other minister shall be appointed by the governor on the advice of the chief minister. So chief minister is appointed by the governor and other ministers shall be appointed by the governor on advice of the chief minister and the ministers shall hold office during the pleasure of the governor. Okay, आहे. Provided that in state of the Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, okay, लक्षात घ्या, okay, there shall be a minister in charge of the tribal welfare who may in addition be in charge of the welfare of the scheduled caste and backward class. बघा, scheduled caste, backward class or any other work. त्याच्यामुळं लक्षात घ्या, statements number 1 to 4, that is option number D is the correct one. Consider the following statements. Okay, या ठिकाणी ओके तुम्हाला काय विचारलं, युनियन टेरिटरी ऑब्लिक स्टेट आणि ते कोणत्या ज्युरिस्डिक्शन, कोणत्या हायकोर्टाच्या ज्युरिस्डिक्शन मध्ये येतं हा प्रश्न विचारलेला आहे. अंदमान निकोबार आयलंड्स, येस, कलकत्ता हायकोर्ट, दिस पेअर इज करेक्ट. मिझोराम, गुवाहाटी हायकोर्ट, दिस पेअर इज ऑल्सो करेक्ट. दादर नगर हवेली, बॉम्बे हायकोर्ट, दिस पेअर इज ऑल्सो करेक्ट. ओके, पुदुच्चेरी, इट डज नॉट कम अंडर द कलकत्ता हायकोर्ट, अंडर मद्रास हायकोर्ट. आणि त्याच्यामुळं 1 to 3 ऑप्शन नंबर सी. पुढचा क्वेश्चन बघा. Which of the following committees recommended that the Panchayat Raj institution should be constitutionally recognized, protected and preserved? Okay, option is LM Singhvi Committee. LM Singhvi Committee राजीव गांधी यांनी 1986 मध्ये स्थापन केली, ते लक्षात घ्या. ओके, त्यांनी काय सांगितलं, लोकल गव्हर्नमेंट शुड बी एक्नॉलेज्ड बाय द कॉन्स्टिट्यूशन. एव्हरी स्टेट शुड एस्टॅब्लिश अ पंचायत राज ज्युडिशियल ट्रायब्युनल. हे वाक्य आता बाकीचे रिकमेंडेशन सुद्धा लक्षात ठेवा. Adequate financial resources for the panchayat. Okay, adequate financial resources for the panchayat should be provided for efficient functioning. Individuals affiliated with the political parties should be discouraged, should not be made part, should be discouraged from participating in the panchayat. The Nyaya Panchayat, okay, Nyaya Panchayat should be tasked with mediating and resolving the disputes. Okay, and rural panchayat should be better organized. So this is LM Singhvi. हा मुद्दा महत्वाचा आहे. Yes. Next question. Okay, with reference to the Jammu and Kashmir Reorganization Act, consider the following statements regarding the Union Territory of Jammu and Kashmir. The Legislative Assembly can make laws on all the matters of the state list under the 7th schedule. The Council of Ministers shall not consist of more than 15%, okay, of the total number of members in the Legislative Assembly. तुम्हाला काय विचारलंय, करेक्ट स्टेटमेंट कोणते आहेत बघूयात जरा काय आहे हा प्रकार. बघा या ठिकाणी, the assembly will have a term of the 5 years and the lieutenant governor must summon the assembly at least once in a 6 months. The legislative assembly may make laws for any part of the union territory of Jammu and Kashmir related to any matter specified in the state list of the constitution except police and the public order and any matter in the concurrent list applicable to the union territories. Further, Parliament will have power to make laws in relation to any matter for the union territory of the Jammu and Kashmir. त्याच्यामुळे पहिलं स्टेटमेंट तर गेलं. The union territory of Jammu and Kashmir will have a council of minister of not more than 10%. दुसरं स्टेटमेंट गेलं, लक्षात घ्या. आणि म्हणून तुम्हाला इथं करेक्ट स्टेटमेंट विचारलंय, एकही करेक्ट नाहीये, neither one, neither nor two. Next question is, which of the following does not describe a feature of the Family Court 1984? Family courts have to be established by High Court in consultation with the state governor. रिव्हर्स केलं, लक्षात घ्या, रिव्हर्स केलेलं आहे आणि त्याच्यामुळे हे स्टेटमेंट चूक आहे. इट मेक्स मॅन्डेटरी टू सेट अप फॅमिली कोर्ट इन एव्हरी सिटी टाउन विथ मोर दॅन 1 million population. दिस स्टेटमेंट इज करेक्ट. Government is free to set up family court in other region if it deems necessary. Yes, it provides that the parties before the family court shall not be entitled as of right to be represented by the legal practitioner. That is also correct, but A is not one. Okay, with reference to electoral constituencies in India, okay, consider the following statement. Boundaries of the Lok Sabha constituencies are not same as the district boundaries. हे मुद्दा आपण आत्ताच बघितला होता. We just had discussed this. कारण का या ठिकाणी काय म्हणू आपण त्याला की कन्सिडरेशन काय असतं की साधारणतः प्रत्येक कॉन्स्टिट्युएन्सी मध्ये जी लोकसंख्या आहे ती एक बरोबर असली पाहिजे, असं त्या ठिकाणी कन्सिडरेशन आहे. त्याच्यामुळं लक्षात घ्या, पहिलं स्टेटमेंट बरोबर आहे. There are many Lok Sabha constituencies in one assembly constituency of each state. हे रिव्हर्स केलं, लक्षात घ्या. हे बघितलं लक्षात येते की एका लोकसभा कॉन्स्टिट्युएन्सी मध्ये अनेक असेंब्ली कॉन्स्टिट्युएन्सी विधानसभेच्या कसं काय असेल, उलट असणार ना. त्याच्यामुळं ओके स्टेटमेंट टू इज इनकरेक्ट, वन ओनली इज करेक्ट. ओके येस, हा सिंपल होता. फक्त प्रेझन्स ऑफ माइंड आपल्याला त्या ठिकाणी पाहिजे. विथ रेफरन्स टू द पॉवर्स ऑफ नॅशनल ह्युमन राईट्स कमिशन, विच ऑफ द फॉलोइंग स्टेटमेंट इज इनकरेक्ट? टू रिव्ह्यू द फॅक्टर्स इन्क्लुडिंग द ऍक्ट्स ऑफ terrorism, its members can visit jail, to study the conditions of inmates. पहिले बरोबर, दुसरे बरोबर आहे. To study the treaties and other international instruments on human rights, that is also correct. It can prosecute the accused in the cases involving violation of the human rights. It cannot prosecute, लक्षात घ्या. When the inquiry discloses the commission of violation of the human right or negligence in the prevention of violation of human right by a public servant, it may recommend to the concerned government authority the initiation of proceedings for prosecution or such other action as the commission may deem fit against concerned person or the persons. आणि त्याच्यामुळं डी हे विधान लक्षात घ्या इनकरेक्ट आहे. पुढचा क्वेश्चन बघा. Consider the following statement with respect to 9th schedule of the constitution. It was added to the constitution through first constitutional amendment act along with article 31B. It intended to protect land reforms. It intended to protect the land reforms from being challenged in the courts on the ground of violation of the fundamental rights. तुम्हाला काय विचारलंय? करेक्ट स्टेटमेंट काय आहे? So consider the statements. The 9th schedule contains a list of the central and state laws which cannot be challenged. झालं, आलं इथं. Which cannot be challenged in the courts. Currently, आता ही additional information लक्षात ठेवा. Currently, 284 such laws are shielded from the judicial review. Most of the laws protected under the schedule concern agriculture and the land issues. His statement लक्षात ठेवा. The schedule became the part of the constitution 1951 when the document was amended for the first time. हे सुद्धा लक्षात ठेवा. It was created by the new article 31B, संपलं, which along with the article 31A was brought in by the government to protect laws related to agrarian reform and for abolishing the zamindari system. While Article 31 extends protection to the classes of the laws, 31B shields specific laws of the enactment. हे समजून घ्या. त्याच्यामुळं जर आपण त्या एक्सप्लेनेशनचा विचार केला तर फर्स्ट अँड सेकंड बोथ द स्टेटमेंट्स आर करेक्ट हियर. चलो नेक्स्ट क्वेश्चन. टीम इंडिया विंग ऑफ द नीति आयोग comprises of Prime Minister and Chief Executive Officer? No. Representatives from every state and the central minister. बघा, हा नीती आयोगाचा एक हब आहे, लक्षात घ्या. टीम इंडिया हब असं त्याला म्हटलं जातं. इट कॅरीज आउट मॅन्डेट ऑफ फॉस्टरिंग कोऑपरेटिव्ह फेडरलिझम. आता कोऑपरेटिव्ह फेडरलिझम म्हटलं की या ठिकाणी काय येणार आहे? दॅट इज रिप्रेझेंटेटिव्ह फ्रॉम एव्हरी स्टेट अँड द सेंट्रल मिनिस्टर्स अँड डिझायनिंग पॉलिसी अँड प्रोग्राम फ्रेमवर्क. इट प्रोव्हाइड्स रिक्विजिट कोऑर्डिनेशन अँड सपोर्ट इन नीति आयोग्स एंगेजमेंट विथ द स्टेट अँड देयरफॉर ऑप्शन बी इज द करेक्ट आन्सर. With reference to Finance Commission, consider the following statements. It is a quasi-judicial constitutional body which is constituted by the President of India. तुम्हाला काय विचारलंय? Incorrect statement आहे. The quasi-judicial constitutional body, yes, it is provided under the Constitution. It is a quasi-judicial, and therefore the first statement is correct. The chairman of the commission should be a person having experience in public affairs. That is also correct. That is also correct. Then recommendation made by the Finance Commission is binding. It is not binding on the central government. It is not binding on the government. आणि तुम्हाला काय विचारलंय? Not correct विचारलेलं आहे. And therefore option C. 3 only. As a court of record, बघा हे वाक्य. As a court of record, high court laws which a high court has which of the following powers? Judgment of the high court are recognized as legal precedents and legal references. Yes. Power to review and correct its own judgment is conferred by the Constitution, and it has power to punish for the contempt of court only with the simple imprisonment. तुम्हाला काय विचारलंय? इनकरेक्ट स्टेटमेंट विचारलंय. सो दुसरा आणि तिसरा बरोबर आहे का? लक्षात घ्या. Article 137 of the Constitution has specifically invested Supreme Court with the power to review any judgment or order passed by it, but the Constitution confers no such power on the High Court. त्या ठिकाणी सेकंड स्टेटमेंट रॉंग गेलं. It has power to punish for contempt of a court only with the simple imprisonment. The Supreme Court and High Courts have power to punish for the contempt of court either with simple imprisonment for a term up to 6 months or with fine up to 2,000 or with both. म्हणजे हे स्टेटमेंट सुद्धा चूक गेलं. कंटेम्प्ट ऑफ कोर्ट म्हणजे काय? As per the Contempt of Courts Act 1971, contempt refers to offense of showing disrespect to the dignity and authority of the court. म्हणून इथे तुम्हाला विचारलं incorrect. Okay, 2 and 3. सोपा होता. Yes, next question बघा. Yes, now we shall be moving to next question. चलो, next question. With reference to statutory grants given under the Article 275, consider the following statements. They are given by the Parliament to the states which are in need of financial assistance and not to the every state. बघूयात काय म्हणते बाबा हे वाक्य. They are given to the states on the recommendation of the Finance Commission. Okay. They give specific grants for the welfare of the scheduled areas in the state and for raising the level of administration of the scheduled tribes in the state. बघा explanation. Explanation काय आहे? Such sums as Parliament may by law provide shall be charged on the Consolidated Fund of India in each year as grants in aid of the revenues of such states as Parliament may determine to be in need of assistance. And different sums may be fixed for different states, provided that there shall be paid out of the Consolidated Fund of India as grants in aid of the revenues of a state. Such capital recurring sums as may be necessary to enable that the state to meet the cost of such schemes of the development as may be undertaken by the state with approval of the scheduled tribes in that state, or raising the level of administration of the scheduled areas therein to that of the administration of the rest of the areas of that state. अशा प्रोव्हिजन्स आहेत. माहिती इथे बघा तुम्ही बघा या ठिकाणी दे आर गिवन टू द पार्लमेंट to the states in need of financial assistance statement बरोबर होता. On the recommendation of Finance Commission हे सुद्धा बरोबर आहे. आता बघा they give specific grants for the welfare of the scheduled areas in the state. नाहीये इथं आपल्याला काय दिसतं हा जो वेलफेअरचा जो एलिमेंट आहे तो शेड्यूल्ड ट्राईबच्या बाबतीमध्ये आहे. अँड फॉर रेझिंग द लेवल ऑफ ऍडमिनिस्ट्रेशन हा जो पॉईंट आहे तो शेड्यूल्ड एरियाच्या बाबतीमध्ये. म्हणजे काय केलं शफल करून टाकला लक्षात घ्या पॉईंट आणि म्हणून 1 आणि 2 बरोबर. तिसरं विधान चूक आहे. ऍज सिम्पल ऍज दॅट. चला पुढचा क्वेश्चन. काय पुढचा क्वेश्चन? Which of the following matters come under the original jurisdiction of the High Court? Disputes relating to the election of the member of parliament, enforcement of the fundamental rights of citizen, any matter related to the criminal offense, the Calcutta High Court have original civil jurisdiction in case of the higher value. चला बघा बरं एक्सप्लेनेशन काय या ठिकाणी. लेट्स कन्सिडर दिस पर्टिक्युलर एक्सप्लेनेशन. हाय कोर्टाला ओरिजिनल ज्युरिडिक्शन कुठं आहे? वेर इट हॅज द ओरिजिनल ज्युरिडिक्शन. Judicial contempt and the matters of admiralty. Disputes involving the election of members of the state legislature and the parliament, done. Regarding a revenue related issue or a task requested or completed in the pursuit of revenue. Enforcement of fundamental rights, done. For example, an aggrieved person can directly go to High Court for the enforcement of his or her fundamental right. Cases in which subordinate court was instructed to move cases involving constitutional interpretation to its own file. आत्ताच आपण बघितलं होतं. The High Courts earlier in that question. The High Courts have sole power to hear civil claims involving the property valued at more than 20,000. The High Courts have authority to consider the election petitions, done. In matters of greater importance, the 4 High Courts, the Calcutta, Bombay, Madras and Delhi High Court have original civil jurisdiction. They are also done. Now, prior to 1973, the original criminal jurisdiction also lay with the Calcutta, Bombay and Madras High Courts through the 1973 Criminal Procedure Code. This was completely eliminated. मग हे जर आपण बघितलं तर 1, 2, 4 are correct. Third is not and hence option C is the answer. चला. Next question. Which of the following urban local bodies are created by an act of state legislature? Town area committee is created by the state legislature. One is the notified area committee is created by notification in the gazette. आणि त्याच्यामुळं 2 असू शकत नाही लक्षात घ्या. 2 नाही आणि ऑल ऑफ द अबव नाही. पोर्ट ट्रस्ट बाय अन ऍक्ट ऑफ पार्लमेंट. ते सुद्धा या ठिकाणी नाहीये. स्पेसिफाईड पर्पज एजन्सी बाय द स्टेट लेजिस्लेचर 4 आहे. कॅन्टोनमेंट बोर्ड बाय कॅन्टोनमेंट ऍक्ट 2006. हे सुद्धा नाही. ऑप्शन बी. इथं लक्षात घ्या प्रत्येक बॉडी कोणत्या कोणत्या उपायांनी तयार केले जाते. दिस हॅज बीन प्रोव्हाइडेड अँड देअरफॉर ऑप्शन नंबर बी A and 4, 1 and 4 आर करेक्ट. नेक्स्ट क्वेश्चन. Consider the following statements. If a legislative council rejects an ordinary bill passed by the state legislative assembly, then a joint sitting can be called by the governor. असं नाहीये लक्षात घ्या. If the 2 houses disagree, the will of the legislative assembly takes precedence. As a result, there is no mechanism of the joint sitting to resolve the deadlock. Therefore, the first statement is incorrect. तुम्हाला कोणत्या incorrect विचारलंय? According to the constitution, parliament can abolish or create a legislative council of any state if legislative assembly of the concerned state passes such a resolution. Okay, that statement is correct one. The money bill can be introduced in legislative council. That is wrong. It is by the legislative assembly, and therefore, okay, what we can say, this statement is also incorrect. 1 and 3. Okay. Next question. With reference to the office of the prophet, consider the following statements. The constitution clearly defines what constitutes an office of prophet. Okay. आता इथं बघा. An office of prophet has been interpreted. Okay. Clearly लक्षात घ्या. Contrasting statement आहे. Direct चूक झालं. Okay. Yes. Under Article 191(1) of the Constitution, an MLA or an MLC is barred from holding an office of the prophet under central or the state government. Okay, that is true. The office of the prophet law simply seeks to enforce a basic feature of the Constitution. The office of the prophet law simply seeks to enforce a basic feature of the Constitution, that is principle of separation of power. लक्षात घ्या. हे जे principle of separation of power आहे त्याच्या enforcement साठी आहे, and therefore the third statement is also correct. Okay, 2 and 3. Next question बघा. Article 243H of the Indian Constitution entitles Panchayat with which of the provisions? Budgetary allocation from the state revenue, okay, share of the revenue of certain taxes, and collection and retention of revenue it raises. Okay, yes, here Article 243H is given. The legislature of the state may by law authorize the panchayat to levy, collect and appropriate such taxes, duties, tolls and fees in accordance with such procedure and subject to such limits. Assigned to panchayat such taxes, duties, tolls and fees levied and collected by the state government for such purpose and subject to such conditions and limit. Provide for making such grants in aid to the panchayats from the consolidated fund of the state. That is also right. The provide for the constitution of such funds for crediting all the monies received respectively by or on behalf of the panchayats, and also for a withdrawal of such monies therefrom as may be specified by the law. बघा, या सगळ्या गोष्टी फिट बसतात का एक्सप्लेनेशन मध्ये? All these elements, all these points, they get fit into that explanation, and therefore 1, 2, 3 is the answer. Okay, next question. Next question. With reference to the GST Council, consider the following statements. Union Finance Minister and Chief Minister of all the states are member of the council. The members of the council include the Union Finance Minister. Ahe ka? Yes. Okay, there is Union Finance Minister. The Union Minister of the state. Okay, Union Minister of the state from the center, and each state can nominate a minister in charge of finance or taxation or any other minister as a member. Okay, so here there is no such thing like chief minister, and therefore this statement goes wrong. The council can recommend the goods and services, okay, recommend goods and services that may be exempted from the GST. Yes, that is the objective, okay, and it meets regularly for the same purpose. The vote of the central government has 50% percentage of total votes in the council. Consider this particular explanation. Clause 9 of the Article 279A deals with voting mechanism in the GST Council meeting, and that states every decision of the GST Council shall be taken at a meeting by a majority of not less than 3/4 of the weightage votes of the members present and voting in accordance with the following principle, namely, the vote of the central government shall have the weightage of 1/3. इथे किती दिलंय? हे दिलं 50%. Go wrong. Statement wrong. Shall have weightage of 1/3 of the total votes cast, and the votes of all the state governments taken together shall have the weightage of 2/3 of the total votes cast in that meeting. So, baga, statement, okay, 2 is only correct, 1 and 3 are wrong. You have been asked to identify the correct statement. Okay, next question. In India, okay, other than ensuring the public funds are used efficiently and for the intended purpose, what is the importance of the office of the CAG? CAG exercises exchequer control on behalf of the parliament when President of India declares, okay, financial or the financial emergency or the national emergency. That is not the case. CAG reports on the execution of projects or programs by the ministers which are discussed by the Public Account Committee. That is true. Okay, information from CAG, okay, reports can be used by investigating agencies to press charges against those who have violated the law while managing the public finances. Yes, that is true. And in last few years, many times that has happened, and that is why it is a matter of what we can say general knowledge or general sense that second and third statements are correct. While dealing with the audit and accounting of the government companies, CAG has certain judicial powers. No, okay, no judicial power for the prosecuting those who violate the law. सो या ठिकाणी 2 and 3 आर करेक्ट. ओके, रेस्ट आर नॉट. देन नेक्स्ट क्वेश्चन, which of the following statements regarding the Election Commission of India is or are correct? The Constitution of India provides that the ECI must comprise of a chief election commissioner and 2 other election commissioners. Okay, let's see. Chief election commissioner has a special vote in case of difference of opinion among the commissioners. Okay, no. Okay, he doesn't have any special veto. The retiring election commissioners are not debarred from any further appointment under the government. Okay, yes, that is correct. Okay, now, as far as the first statement is concerned, the election commission shall consist of the chief election commissioner and such number of other election commissioners, if any, as the president may from time to time fix, and the appointment of the chief election commission and other election commissioners shall subject to the provisions of any law made in that behalf by the parliament may be made by the president. आता बघा या ठिकाणी कॉन्स्टिट्यूशन ऑफ इंडिया प्रोव्हाइड्स दॅट. नो. ओके, कॉन्स्टिट्यूशन ऑफ इंडिया doesn't provide that chief election commission plus 2 other election commissioner. No, number is decided by the by the president. Okay, yes. Next question is, with reference to the Gram Nyayalaya Act, which of the following statements are correct? As per the act, the Gram Nyayalayas can hear only the civil cases. No, they can hear civil as well as the criminal cases. आणि म्हणून पहिलं स्टेटमेंट चूक जातं. The act allows local social activists as mediators and conciliators. हे स्टेटमेंट मात्र बरोबर आहे, लक्षात घ्या. ओके, अँड दॅट इज वाय काय म्हणू आपण त्याला की न्यायाधिकारी हा जो अधिकारी असतो, दिस पर्टिक्युलर ऑफिसर इज एम्पावर्ड टू हिअर बोथ सिव्हिल अँड द क्रिमिनल केसेस. ओके, येस. ज्युरिडिक्शन ऑफ द ग्राम न्यायालय. Notwithstanding anything contained in the Code of the Criminal Procedure 1973. So, Code of Criminal Procedure, criminal cases, or the Code of Civil Procedure, civilian matters as well, or any other law for the time being in force, the Gram Nyayalaya shall exercise both civil and criminal jurisdiction in the manner and to the extent provided under this act. Okay, so this is the provision, and therefore the first statement is wrong. Okay, yes. Next question. Consider the following statements with reference to Central Bureau of Investigation. It cannot investigate cases within the state without the consent of the respective state government. Yes. Okay, that is why, many times it becomes a matter of controversy, political controversies. Okay, yes, it can sumo to take up investigation of any crime anywhere in the country. No, this is also not correct. Okay, yes, okay, this is correct. Okay, yes, it can sumo take up the investigation of any crime. No, this is not correct. It acts as the nodal agency for the extradition of the fugitives. Bada. The Ministry of External Affairs is the nodal agency for the extradition of fugitives, and therefore this statement is also incorrect. CBI Interpol can help the law enforcement agencies in tracing or locating the fugitives so that it can make a formal request for extradition of fugitives to the MEA. Okay, and therefore the third statement is wrong. You have been asked to identify the correct statement, one only. Okay, next question. Consider the following statements with respect to the Lok Adalat. Cases involving non-compoundable offences where no compromise is allowed cannot be settled in the Lok Adalat. Okay, that is the purpose basically. Okay, non-compoundable offences and where no compromise can be sought or no compromise is allowed. Okay, that is not jurisdiction. Okay, that those cases do not pertain to the Lok Adalat. आणि म्हणून पहिलं स्टेटमेंट हे बरोबर आहे. The awards given by the Lok Adalats are not binding on the parties. Okay, that is not true. The awards are binding. Lok Adalat lacks a statutory status. No. Okay, yes, it is. This statement is wrong because Nalsa is there. We know that Nalsa, and therefore second and third statement are incorrect. First statement is correct. Okay. Next question. Next question is, consider the following statement with reference to All India services. The officers of the AIS can be dismissed from services only by the president. That is true. We know that. Rajya Sabha is the only sole authority to establish new AIS. No, it is not sole authority, but it only can initiate the process. Okay, या प्रक्रियेची सुरुवात ही राज्यसभेतच सुरू होत आहे, पण याचा अर्थ नाही की राज्यसभा is sole authority, and therefore this statement is wrong. Okay, तुम्हाला correct statement, you have been asked to identify the correct statement, and one only is the correct statement. Which among the following is the changes brought about by 73rd Amendment in the Panchayat Raj institutions? A uniform three-tier Panchayat Raj structure in every state. बरोबर आहे. Okay, village level, intermediate level, and the district level. All the 3 levels of the Panchayat Raj institutions are elected either directly or indirectly. That is also correct. Okay, as far as these members are concerned, direct election. As far as the chairpersons are concerned, indirect. And therefore, yes, the first statement is correct. Okay, the second statement is also correct. And therefore, answer should be 1 and 2. One half of the positions of all panchayat institutions are reserved for the women. Okay, that is not the case. Okay, we know that 1/3 positions are reserved, and therefore 1 and 2 are the correct option number A. Next question. Okay, next question. Which of the following are the necessary conditions for a political party to get recognized? Okay, to get recognized as a national party. Okay, which of the following are the necessary conditions for a political party to get recognized as, okay, the national party? At a general election to the Lok Sabha or the legislative assemblies, the party polls 6% of votes in 4 states, and in addition, it wins 4 Lok Sabha seats from any state or the states. Okay, baga. A party is recognized as a national party if any of the following conditions is fulfilled. If it secures 6% of the valid votes polled in any four or more states at a general election to the Lok Sabha or to the Legislative Assembly, and in addition, it wins 4 seats in Lok Sabha from any state or the states. Yes, it matches, it fits the criteria. Okay, and therefore the first statement is correct. A party gets recognition as a state party in 4 or more states. Okay, if it wins, so the third step, if it is recognized as a state party in the 4 states, so this statement is also correct. Okay, the party wins 6% of the seats in the Lok Sabha from at least 3 different states. Okay, itha asa hai ka? Yes. Okay, if it wins 2% of the seats in the Lok Sabha at a general election, and these candidates are elected from 3 states, itha not 6% but 2%. So here is the problem. Okay, so 1 and 2 only are correct. Okay, next question. Which of the following changes were made by 97th Constitutional Amendment Act 2011? It made right to form cooperative societies a fundamental right. Okay, that is true. It added a new directive principle of state policy on promotion of the cooperative societies. That is also correct. It made participation of cooperative societies a fundamental duty. No, this is not the provision. Okay, yes, consider this explanation. An act further to amend the Constitution of India, be it enacted by the Parliament in the 62nd year of the Republic of India as follows. This act may be called as Constitution 97th Amendment Act 2011. It shall come into force on such date as the central government may by notification the official gazette appoint. In part 3 of the Constitution, in Article 19, in clause 1, subclause C, after the words or unions, the words or cooperative societies shall be inserted. So yes, statement is correct. The part B of the Constitution, part 4th of the Constitution, after Article 43A, the following article shall be inserted, namely 43B. The state shall endeavor to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Yes, okay. Amendment of Article 19, insertion of new Article 43B, and promotion of the cooperative societies. Oh, yes. Okay, so 1 and 2 correct. The third is not correct. Okay. Next question. Which of the following are covered under the jurisdiction of the Lokpal? Okay. Prime Minister, institutions aided by the government, institutions partly financed by the government, and judiciary. Prime Minister, ministers, members of the Parliament, Group A, B, C, and D officers, and officials of the central government. So first statement is correct. Any person who is or has been the chairperson of a member or officer or employee in any body or board or corporation or authority or company or society or trust or autonomous body by an act of Parliament or wholly or partly financed by central government or controlled by it. Okay, yes. But institutions aided by the government and judiciary are not the part of the Lokpal. And as far as judiciary is concerned, okay, there is a major criticism of this institution. Okay, yes, you know that. The qualification and eligibility conditions for the selection of members of Finance Commission shall be decided by, okay, it is provided that, okay, these conditions are determined by the Parliament of India. Okay, then Article 371 of the Constitution of India provides special provision for which of the following states? Assam, Meghalaya, Manipur, and Tripura. We know that Article 371 provides special provision with respect to the states of Maharashtra and Gujarat, and therefore Okay, nota, none of the above is the answer. Okay, next question. Consider the following statements about Defense Acquisition Council. It is chaired by Prime Minister. No, it is not chaired by the Prime Minister. It is chaired by the Defense Minister. And therefore, the first statement is incorrect. You have been asked to identify the correct statement. Second statement, let's check. It is the highest decision-making body for capital acquisition proposals of the Indian Armed Forces. Okay, this is the correct statement. Okay, yes. Next question. With respect to the supervisory jurisdiction of the High Court, consider the following statements. The power of superintendence of the High Courts extends over all the courts except military and tribunals in its territorial jurisdiction. The jurisdiction, however, comes only on application of a party and cannot be taken by High Court on its own. The High Court deals with the appointment, transfer, posting of all the judges within the state. Asa hai ka? Okay, no. Okay, lakshat dhya. The first statement is definitely correct. Okay, only on the application, no. High Court so motu can take the action. The High Court deals with appointment, transfer, posting of all the judges within the state. That is also not correct. Okay, so option A, statement 1 only is correct. Okay, yes. Which of the following items are included in 12th schedule of the Constitution? Okay, cattle pounds, prevention of cruelty to animals, social forestry and farm forestry. Okay, then solid waste management, then roads and the bridges. Okay, roads and the bridges, non-conventional energy sources. Okay, yes, consider roads and bridges, police, health, sanitation, conservation, solid waste management, cattle pound, prevention of cruelty to the animal. Okay, cattle pound, prevention of cruelty to animals, solid waste management, roads and the bridges, 1, 3 and 4. Okay, these are what we can say the items included in the what we can say 12th schedule. Okay, and therefore, okay, these are the right options here. Now, next question. Okay, consider the following statements with reference to the government of National Capital Territory, NCT of the Delhi. The 69th Constitutional Amendment Act 1991 provided for the inclusion of the members of the Legislative Assembly of NCT of Delhi in the Electoral College for the election of the President. Okay, is that so? Consider. As per Article 54 of the Constitution, the President of India is elected by the members of an electoral college consisting of the elected members of both houses of parliament, the elected members of the legislative assemblies of all the states, including NCT of Delhi and Union Territory of Puducherry. So yes, the members nominated to either house of the parliament or legislative assembly of the states, including NCT of Delhi and UT, are not eligible to be included in the electoral college. Okay, yes. So here the statement 1 is correct. The Lieutenant Governor has discretionary powers even in the matters where Legislative Assembly of Delhi is empowered to make the laws. Okay, this is the recent amendment, Government of NCT of Delhi Amendment Act 2021. It gives discretionary powers to the Lieutenant Governor even in the matters where the Legislative Assembly of Delhi is empowered to make the laws, and therefore both the statements are correct. Yes. Okay, next question. Consider the following statements with reference to the Solicitor General of India. This post is statutory in nature. Solicitor General's office and duties are governed by the Law Officers Rules 1987. Thus, they are statutory post and not the Constitution. So, yes, pehla barobar hai. He or she is the government's chief legal advisor and its primary lawyer in the Supreme Court of India. No, we know that it is Attorney General. He or she is appointed by the President of India. Okay, baga. The Solicitor General is appointed for the period of 3 years by appointment committee of cabinet chaired by the Prime Minister. Okay, and therefore, इथं जरी आपण president जरी म्हटलं तरी 1 and 3 are not the option, and therefore we will take 1 as an answer and A is the option. Okay, the third statement is wrong, and there is no option as well. Okay, yes. Next question. Which of the following factors are considered while delimitation of the constituencies in Jammu and Kashmir? Okay, as a provision in the Delimitation Acts from 1952 onwards, which says other than the population, factors like physical features, boundaries of administrative units, okay, communication, facilities, and public convenience should be taken into the account. All these factors are there, and therefore 1, 2, 3, 4 is the answer. Okay, yes, consider this point. Recently, this has been in news, and therefore it is very, very important one. Now we shall take next question. Next question is, which of the following statements are correct regarding the National Commission for the Scheduled Caste? It consists of a chairman, vice chairman, and 3 other members were appointed by the president. Yes. This statement बरोबर आहे का? Definitely, this statement is right. It investigates and monitors all the matters relating to the constitutional and other legal safeguards for the SCs. Okay, so this is simple question actually. The central and the state government are required to consult commission on all major policy matters affecting to SCs. That is also correct, and it is rather actually the earlier the National Commission for the Scheduled Caste. It was entrusted with the concerns of the scheduled tribes, OBCs, okay, as well. But eventually there is a separate National Commission for the STs, and there is commission for the OBCs as well. But now, as of now, the National Commission for Scheduled Caste, it takes into account, or it is concerned with the issues of scheduled castes as well as the Anglo-Indians. Do you remember that? The concerns of the Anglo-Indians are also taken care of the National Commission on Scheduled Caste as of now. Okay, हा point तुम्हाला इथं लक्षात ठेवायचा आहे. And therefore 1, 2, 3 are the right statements. Next question. Next question is, consider the following statements with respect to the Central Vigilance Commission. The CVC is an investigating agency. Okay, yes. Yes. I think this particular element has been posted wrong. But the National Commission for Scheduled Caste is a constitutional body established with a view to provide safeguards against the exploitation of scheduled caste and Anglo-Indian communities to promote and protect their social, education, economic, cultural interest. Article 338 of the Indian Constitution deals with the National Commission on Scheduled Caste. Okay, yes. Now let's consider the point regarding CVC. It has been posted wrong. Okay, so now let's consider the points regarding CVC. The CVC is an investigating agency. It aims to address corrupt practices within the central government. It has only an advisory role and cannot register criminal cases against the government officials to initiate the inquiries. You have been asked to identify the correct statement. The CVC is not controlled by any ministry or department. Consider this particular statement, which is important. It is an independent body which is only responsible to the parliament. Do remember, this is important point regarding the Central Vigilance Commission. The CVC is not an investigating agency. It is not. Okay, it is not an investigating agency. Yes. Okay, it is not an investigating agency, and therefore the statement is wrong. Okay. The CVC either get the investigation done through the CBI or through the departmental chief vigilance officers. Secondly, the CVC orders investigation into cases of officials of central government, department, companies, organizations only. The commission is empowered to inquire or cause inquiries to be conducted into the offices alleged to have been committed under the Prevention of Corruption Act 1988. Okay, yes. So herein the statement number 2 and 3 are correct. Okay, but the first is not one. Chalo. Next question. Yes. Consider the following statements regarding Armed Forces Special Powers Act AFSPA in India. The Ministry of Home Affairs, MHA, is responsible for the imposition of AFSPA in the UTs of Jammu and Kashmir and Ladakh after the reorganization. That is true. Presently, it is applicable in the entire state of Arunachal Pradesh and Nagaland. Okay, this is the part of the current affairs, and let's check the validity of this particular statement. Okay, let's check the validity of this statement. The AFSPA, under which a geographical location is declared as disturbed area to facilitate the operations of the armed forces, will now be applicable fully only in 31 districts and partially in 12 districts of 4 states in the Northeast Assam, Nagaland, Manipur and Arunachal Pradesh. These 4 states together comprise 90 districts. Okay. And then AFSPA Act 1958 was completely withdrawn in the Meghalaya in 2018, Tripura in 2015 and Mizoram in 1980s. And therefore, the second statement is wrong. The first statement is correct. Option A is the answer. Okay, let's move to the next question. Next question. Consider the following statements with respect to administrative tribunals. Article 323A, okay, provides for the establishment of administrative tribunal. That is true. The Santhanam committee recommended for the establishment of administrative tribunal. That is wrong. Okay, it provides for the CVC. Administrative tribunals adjudicate disputes relating to recruitment and conditions of service of persons appointed to the public service. Parliament may, by law, provide for administrative tribunals of disputes and complaints with respect to the recruitment and conditions of the service of the persons appointed to a public servants, services and post in connection with the affairs of the union or of any state or of any local or other authority or of any corporation owned by or controlled by the government. Okay, and therefore, okay, this statement is correct, this statement is correct, this statement is wrong. Okay, yes. Chalo. Next question. Consider the following statements with respect to National Human Rights Commission, NHRC. The NHRC is a constitutional body. No, it is not constitutional body. The annual report of NHRC is submitted to the central government, which in turn submits to Parliament. That is true. Okay, it is provided by law, NHRC Act. It only has, okay, the recommendatory powers with no penal provisions for its non-implementation. That is true. And this is one among the major criticisms of the NHRC. But NHRC says that, okay, what we can say, as far as the human rights commissions of other countries are concerned, the uniqueness of the Indian NHRC is, okay, Indian Commission is, okay, the what we can say, the task of protection of the human rights in India is entrusted with the members of the judiciary, and which is found nowhere in the world. Okay, that is said by the National Human Rights Commission. So while it is criticism, but the uniqueness is, okay, judicial members are there. Okay, yes, consider this point. It is not constitutional body or other statutory, and therefore, okay, what we can say, the options C, 2 and 3 are correct. Yes. With reference to the doctrine of severability, consider the following statements. It flows from part 3 of the Constitution. Article 13, when a certain section of a law violates fundamental constitutional rights and can be isolated from the rest of the legislation, the court will declare that provision unconstitutional rather than the entire statute. Okay, and therefore the first statement is correct. Okay, we shall see what exactly is the doctrine of severability. It was used by Supreme Court of India to strike down the 97th Constitutional Amendment Act. Is this statement correct? The doctrine of severability states that when a certain section of a statute's provision becomes unconstitutional, but that component can be separated from the rest of the legislation, the court will declare just that part illegal, not the entire statute. The rest of the law will remain in force. म्हणजे काय? एखाद्या कायद्याचा एखादा भाग लक्षात घ्या, एखाद्या कायद्याचा एखादा भाग हा अनकॉन्स्टिट्युशनल आहे असं कोर्टला जर वाटत असेल तर कोर्ट काय करेल, तेवढाच भाग सेव्हिअर करेल. सेव्हिअर कायदा म्हणजे काढून बाजूला ठेवेल. ओके, बट पूर्ण कायदा त्या ठिकाणी ओके काय इनव्हॅलिड ठरवला जाणार नाही. द रेस्ट लॉ विल रिमेन इन फोर्स. यालाच आपण डॉक्ट्रिन ऑफ सिव्हिलिटी असं म्हणतो. So basically what had happened, part 9th B introduced in constitution through 97th amendment, okay, dictated the terms for running the cooperative societies. The provisions in the amendment passed by the parliament without getting them ratified by the state legislature as required by the constitution. म्हणजे काय, 97th amendment ऍक्ट करत असताना पार्लमेंटने अशा काही तरतुदी केल्या जे करत असताना त्यांनी स्टेट गव्हर्नमेंटची परवानगी घेणं अपेक्षित होतं, पण त्यांनी ते घेतलेलं नव्हतं आणि म्हणून ते अनकॉन्स्टिट्युशनल होईल का असा प्रश्न निर्माण झाला. It went to the extent of determining the number of directors a society should have, or their length of tenure, and even the necessary expertise required to become the member of the society. आणि त्यांनी काय केलं, त्या कोऑपरेटिव्ह सोसायटी डायरेक्टर किती असले पाहिजेत, त्यांचं टेन्युअर किती असलं पाहिजे आणि त्याचे क्वालिफिकेशन काय असले पाहिजेत. बट दीज आर द मॅटर्स ऑफ द स्टेट. Within their own spheres, the states have exclusive power to legislate on the topics reserved exclusively to them. Part 9th B, which consists of Article 243ZH to 243ZT, has significantly and substantially impacted state legislatures' exclusive legislative power over its cooperative sector under entry 32 of the state list. Okay, so it is a part of state list. Article 243ZI makes it clear that a state may only make law on the incorporation, regulation, and winding up of a society subject to the provisions of Part 9th B of 97th Amendment Act, and therefore here comes the doctrine of severability. Okay, and therefore both the statements are correct. Okay, next question. Consider the following statements. Right to property as a fundamental right was abolished by 42nd Amendment Act. No, by 44th Constitutional Amendment Act, and therefore this statement is wrong. Article 31A saves the acts and regulations included in the 11th schedule from being, 9th schedule, my mistake, included in the 9th schedule from being invalidated on the ground of contravention of any of the fundamental rights. Is it any? No, it is Article 14 and Article 19. Consider this particular point. Article 31A saves 5 categories of the laws from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14 and 19. Okay, Article 14 and 19. It includes acquisition of estates and related rights by the state, taking over the management of the properties by the state, amalgamation of the corporations, extinguishment or modification of rights of directors or shareholders of the corporation, extinguishment or modification of the mining leases. Okay, and therefore here, okay, correct statement has been asked. So both the statements are wrong. Okay, next question. Consider the following statement. Appointments and promotion of district judges in any state shall be made by the governor in the state in consultation with the High Court exercising jurisdiction in relation to such state. That is true. A person not already in the service of the union or of the state shall only be appointed as a district judge if he has been advocate for not less than 5 years. No, provision is at least 7 years. Okay, and therefore the second statement is, okay, incorrect, and you are asked to identify the correct statement. The one is correct statement. Okay, next question. Which of the following features of the Constitution of India is borrowed from the Weimar Constitution? It's very simpler one. Okay, suspension of fundamental rights during the emergency. Okay, we know that during 1930s, 40s, okay, the German Hitler's regime in Germany. Okay, Weimar. Before Hitler's regime in Germany, there was this Weimar Constitution, and this Weimar Constitution has specific provisions associated with suspension of the fundamental rights. Why? Because there was huge grievances and resentment among the society, and okay, whenever there was such resentment, okay, grievances expressed, okay, through the unconstitutional channels, okay, there would be the suspension of the fundamental rights, and therefore the option C is the correct answer. Okay, next question. Which of the following statement is incorrect regarding India's anti-defection law? Recently, it has been in news because of the issue in the Maharashtra. It was included via the 52nd Amendment Act 1985 under the 10th schedule of the Constitution. Okay, yes, you have been asked to identify the incorrect statement. So the first statement is correct. Okay, the decision on questions regarding disqualification on ground of the defection taken by the chairman or the speaker of such house is not subject to judicial review. No, it is subjected to the judicial review. Okay, those people who are following the news, okay, they can definitely, okay, identify the incorrectness in this statement. The law does not provide a time frame within which the presiding officer of the house has to decide the defection case. That is also correct. The grounds for disqualification include an elected member who is voluntarily giving up his or her membership of a political party. Okay, that statement is correct. Incorrect statement is only B. Okay, only B. Next question. Which of the following statement is or are correct regarding the constitutional position of the Hindi language? Hindi written in Devanagari script is to be the official language of the Union. हे बरोबर आहे. The form of numerals in the Devanagari script is to be used for the official purpose of the Union shall be the international form of the Indian numerals. Okay, that is true. International numerals या ठिकाणी वापरले जातात. It was decided at the enactment of the Constitution that for a period of 15 years, the English language would be continue to be used for all the official purposes. That is also true. सुरुवातीला 15 वर्ष होतं, पण नंतर मग जेव्हा साऊथ इंडियन स्टेट्स कडून एक अपोजिशन यायला लागलं, then eventually the decision was taken that English should also be continued. But earlier it was only for the 15 years. Okay, that is also provided. Okay, so that is why the option number D, 1, 2, 3 is the correct one. Next question. Consider the following statements regarding the judicial activism. The concept of the judicial activism originated and developed in USA. Yes, that is true. Okay, judiciary there has certain overarching powers, and therefore the concept of judicial activism has been originated into the USA. Okay, the next question is, it has both positive and negative connotations in the jurisprudence. That is also true. What is positive connotation? So या ठिकाणी काय असतं आपल्याला लक्षात घ्या की whenever, okay, executive असेल, legislature or executive, when they fail to perform their duties, okay, त्या ठिकाणी कुठल्याही विशिष्ट कारणामुळे एक्झिक्युटिव्ह आणि लेजिस्लेचर जेव्हा इफिशियंटली काम करणार नाही, त्याला एक वॉचडॉग म्हणून, ओके, लक्षात घ्या, नागरिकांच्या, लोकांच्या हक्काच्या रक्षणार्थ ज्युडिशरी पुढे येते. It takes the suo cognizance of such things, and it actively intervenes, and thus it protects the rights, okay, of the people. It fulfills it takes care of the concerns of the people, interests of the people, and this is the positive connotation of the judicial activism. But what about negative connotation? Okay, it hurts the idea of the separation of power. Okay, judiciaryचा एक, okay, लक्षात घ्या, त्यांचा एक स्वतःचा झोन आहे, एक्झिक्युटिव्हचा एक झोन आहे, लेजिस्लेचरचा एक झोन आहे. But many times what happens, okay, judiciary tries to step into the shoes of executive and legislature, and it does not have the sufficient or the necessary mechanism to do that, and therefore many times, okay, there is a conflict. and therefore it is the negative connotation. Okay, lakshat घ्या. Okay, and therefore, okay, incorrect statement, both are correct and therefore neither is incorrect. Okay, next question. With reference to the provisions of Panchayat extension to scheduled areas Act 1996, consider the following statement. Gram Sabha is responsible for the identification of beneficiaries for the poverty alleviation program. That is true. Gram Panchayat does the actual planning. No, Gram Sabha does the planning and implementation of development project in the scheduled areas. The reservation for the scheduled tribes in Panchayat shall not be more than 1/3 of the total number of states. No, it is less than 1/2. असं सांगितलेलं आहे, and therefore 2 and 3 statements are okay, not correct. Okay, yes, 2 and 3 only. You have been asked to identify the incorrect statement, and the first statement is correct, and therefore 2 and 3, these two are the incorrect statements. Yes, option number D should be the answer here. D. Okay, next question. Consider the following statements about the National Legal Services Authority, NALSA of India. It is a statutory body to provide free legal services to weaker sections of society. That is true. And which sections get help under this particular NALSA? The member of scheduled caste or the scheduled tribe, a victim of trafficking in human beings or beggar, a woman or a child, a mentally ill or otherwise disabled person, victim of a mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake or industrial disaster, or an industrial workman or person in custody. Okay, या लोकांना त्याचा काय म्हणू आपण त्याला की सर्व्हिसेस मिळतात. It provides legal aid with respect to both civil and criminal cases. That is also true. Any judge of the Supreme Court shall be the patron in chief. No, the Chief Justice of India is the patron in chief. Okay, election. Yeah. Next question. With reference to the part 9th of the Constitution, consider the following statements. All the seats in Panchayat Raj shall be filled by direct election from territorial constituencies in that Panchayat area. 1/3 officers, offices of the chairperson at all levels of Panchayat Raj institutions are reserved for the women. So second statement is correct. All the seats in Panchayat Raj institutions shall be filled by direct election. That is true. Offices, chairpersons are in direct election, and what we can say, seats are by the direct election, and therefore both 1 and 2 are correct. Option number C is the answer. Next question. Consider the following statements about National Commission for Minority Education Institutions. It is a constitutional body established under Article 350B of the Indian Constitution. Is that so? No. Consider this argument. The National Commission for Minority Education Institution was set up in 2004. The government brought out an ordinance in November 2004 establishing the commission. Later, a bill was introduced in Parliament in December 2004, and both houses passed the bill. And NCMEI Act was notified in the January 2005. So it is statutory, not the constitutional. Okay, and therefore, this statement is wrong. It regulates the certification of minority education institutions all over the country. Okay, yes, it does not have the authority to cancel the minority status granted to the institution. Commission has the power to cancel the minority status of an education institution on grounds laid down in the Act, and therefore the third statement is incorrect. 2 only is the correct one. Okay, chalo, next one. Next question. Which of the following items are listed under the concurrent list 3? That is list 3 of the Indian Constitution. Insurance, that is insurance is under entry 47 of the Indian Constitution, and therefore this cannot be the option. Okay, relief of the disabled and unemployable, entry 7 of the state list. Okay, electricity, entry 38 in the concurrent list. Taxes on sale of the electricity, entry 53 of the state list. Okay, so this is not also applicable. Bankruptcy and insolvency, entry 9 in the concurrent list. Marriages and divorce, entry 5 in the concurrent list. So 3, 5, 6, option C is the answer. Yes, next question. What special powers are given to the governor in case of a tribal areas under the 6th schedule? The governor can organize and reorganize the autonomous districts. Yes. In case of different tribes in an autonomous district, the governor can divide district into the several autonomous regions. So 1 and 2, they are related to each other. He or she can declare any area to be the scheduled area. No president can declare it. The governor is empowered to appoint a commission to examine and report on any matter relating to the administration of the autonomous district or the region. Okay, that is true. And therefore, 1, 2, and 4 are the right options. Next is, consider the following statements with reference to the pressure groups. They represent heterogeneous groups that seek to contest for the government offices. Okay, they represent heterogeneous groups that seek to contest for the government offices. Is that so? The members of the pressure group, do they contest for government offices? No, they do not do so. They remain outside the government and try to influence the government, okay, by their pressure tactics. And therefore, first statement is incorrect. They are partisan in character. They are partisan character and stick to their affiliated political party lines. That is also not correct. They are concerned with they are partisan to their own interest, and therefore they can change the positions. And therefore, the statement 2 is also incorrect. There is no law regulating the lobbying by pressure groups in India. Okay, that statement is actually correct. And therefore, option D is the right one. Next is, who among the following takes part in the appointment of High Court judge? Okay, consider this particular explanation. The proposal for an appointment of a judge of a High Court shall be initiated by the Chief Justice of the High Court. The process is initiated by Chief Justice of the High Court. However, if the Chief Minister desires to recommend the name of any person, he should forward the same to the Chief Justice for his reconsideration. So, Chief Minister. Since the Governor is bound by the advice of the Chief Minister, heading the Council of Ministers, a copy of the Chief Justice's proposal with full set of papers should be simultaneously sent to the Governor to avoid the delay. Similarly, a copy thereof may also be endorsed to the Chief Justice of India and Union Minister of Law Justice to expedite the consideration. The Governor, as advised by the Chief Minister, should forward his recommendation along with the entire set of papers to the Union Minister of Law as early as possible. So, President, yes. Okay, Governor, Chief Justice of India, yes. Governor of the concerned state, yes. Chief Justice of the concerned state, yes. But Chief Secretary, Leader of Opposition, okay, these are not involved. Directly procedure is given in the explanation, and therefore options 1, 2, 3, 4 are correct. Okay, he procedure आहे. लक्षात घ्या. Then consider the following statements with reference to the civil servants of India. All the civil servants under the Union and states hold office during the pleasure of the President. Okay, yes, that is true. Under Union and states, okay, that is not true actually. The civil servants under the Union states, all, not all. Okay, then a civil servant cannot be dismissed by an authority subordinate to that by which he was appointed. That is true. The constitutional protections are only available to the civil servant serving under the Union of India. Okay, that is also not true. And therefore, 1 and 3 are incorrect. The second statement is correct. Okay, yes. Next question. Consider the following statements with respect to the special officer for the linguistic minorities. The original constitution did not make, the original constitution did not make any provision. The linguistic minorities are considered as a group or collectivities of individuals residing in the territory of India or any part thereof having a distinct language or script of their own, language or the script. Linguistic minority, language or the script. Although the word linguistic minority is not defined in the Constitution of India, but the language of the minority group need not be, one of the 22 languages, mentioned in the 8th schedule of the Constitution. The States Reorganization Commission 1956 recommended for the creation of a mechanism to address the grievances of the linguistic minorities. Based on the recommendations of the SRC, 7th Constitutional Amendment Act was enacted, whereby Articles 350A and B were included in the Constitution. Article 350B provides for the special officer for linguistic minorities, who is known as the Commissioner for Linguistic Minorities in India, to investigate all the matters relating to the safeguards provided for the linguistic minorities in India under the Constitution. Now, the first statement is correct. And at the central level, the Commission falls under the Ministry of Home Affairs. No, it falls under the Ministry of Minority Affairs. And therefore, option 1, correct option is A. Statement A. Next question. Consider the following statements regarding the Joint State Public Service Commission. It is created by an act of Parliament at the request of concerned state legislature. Yes. The annual performance report of the Joint Public Service Commission is placed before the House of Parliament. No, concerned state legislature. By the President. No, concerned Governor. And therefore, this statement is incorrect. The chairman and members of the commission may resign from their office by submitting their resignation letter to the concerned state governors. No, President. And therefore, the 2 and 3 statements are incorrect. And the correct statement is 1 only, option A. So next question is, Consider the following statements regarding National Education Policy 2020. Okay, National Education Policy 2020. Here is some details of the National Education Policy. Let's see the points. It brings children between 3 to 6 years of age under the school curriculum. It is one among the major highlights of this policy. Okay, it aims to achieve the 100% gross enrollment ratio from preschool to secondary level by 2030. That is true. It restructures school curriculum and pedagogy into new 5+3+4 format. Let's see. It aims to phase out 3-language formula gradually to reduce the burden on the pupil. Okay, yes. For schools from 10+2 to 5+3+3+4. Okay, and therefore that statement, the third statement is wrong. 5+3+3+4. But here it is given 5+3+4. Rather, it should be 5+3+3+4. Okay? Yes. Okay. Current 10+2 structure in which policy covered schooling from 1 to 10, age 6 to 16, and then class 11 to 12, 16 to 18 age, gives way to 5 years of foundational education, 3 years of preparatory, 3 of middle, and 4 years of secondary education. And hence, the formula is 5+3+3+4. Okay, consider this particular point. Okay, 5 years of foundation, 3 years of preparatory, 3 of middle, and 4 years of secondary education. Multi-stream, flexibility to choose subject across the stream, all subjects to be offered at 2 levels of proficiency. Diluted board exam to test only core competence could become modular and will be offered twice a year. Multilingual. The 3-language policy to continue with preference for local language medium of instruction till class 8. Yes, so that is what we can say. The statement was wrong. Okay, so consider this point. Yes, this statement is wrong and this statement is also wrong, and therefore the statements 1 and 2 only are correct one. Yes. Next question. Next question is which among the following are the mechanisms for citizens' participation in the governance process? म्हणजे गव्हर्नन्सच्या प्रोसेसमध्ये सिटीजन पार्टिसिपेशन कसं वाढेल यासाठी मेकॅनिझम कोणते आहेत? राईट टू इन्फॉर्मेशन. येस, डेफिनेटली. Under right to information, people seek the information, they are curious, they ask the questions to the government, and if any discrepancies are found, they can definitely question the concerned government, and therefore right to information. Definitely. Grievance redressal mechanism. आता हे मेकॅनिझम सुद्धा काम करतं, कारण ग्रीव्हन्स रिड्रेसलच्या माध्यमातून गव्हर्नमेंटला लक्षात घे की लोकांना गव्हर्नमेंट सोबत बोलण्याची संधी मिळते किंवा आपले कन्सर्न्स रिप्रेझेंट करण्याची संधी मिळते, and that encourages the participation. Social audit, yes, definitely. Okay, any project, if it is to be evaluated, the people are incorporated into the evaluation process, and therefore it also encourages the citizens' participation. But centralized planning is done at the top level. It is top down approach, not the bottom up approach. Okay, centralized planning काय करते? लोकांना कन्सर्न न करता गव्हर्नमेंट आणि ऍडमिनिस्ट्रेशनच्या लेवललाच ती प्लॅनिंग केली जाते. त्या ठिकाणी लोकांचा किंवा नागरिकांचा विचार केला जात नाही, अँड देअरफॉर द फोर्थ स्टेटमेंट इज रॉंग. ऑप्शन इज सी 1, 2 and 3. Yes. Okay, so this was the 75th question. Now we shall move to the 76th one. So question number 76. Consider the following difference between state and the society. State is politically organized society. Okay, is that correct? That is definitely correct. The state is generally considered prior to the society. That is no. Okay, this statement is incorrect one. Why? Because how could we define the state? Okay, state is basically the component of 4 things: territory, people, government, and sovereignty. When these 4 elements they come together, then it becomes the state. Okay, right? And therefore, here the element of people is important. And the second statement, it said that the state is generally considered prior to the society. No, society is prior to the state. When the people belonging to particular territory, in order to manage their own affairs, they form the government, and the sovereignty is rested with the government, then it becomes the state. And therefore, the second statement is incorrect. Okay, so option number B, 2 only, is the correct option. Okay, yes. Next question. The Niti Aayog was established as the successor to the erstwhile Planning Commission. In the context of Niti Aayog, consider the following statements. Niti Ayog is an extra constitutional body created by parliamentary resolution. Is this statement correct? Okay. No. It is by the cabinet resolution. The President of India is the chairperson of Niti Ayog Governing Council. Okay. That is also incorrect. Prime Minister. The Development Monitoring and Evaluation Office, DMEO, Government of India is attached office under the Niti Ayog. Okay. That is all. That statement is rather correct. Okay. See. Niti Ayog's governing council is the premier body tasked with evolving a shared vision of national priorities and strategies with active involvement of states and union territories. The governing council presents a platform to discuss intersectoral, interdepartmental and federal issues. It comprises the Prime Minister of India, chief ministers of all the states and union territories with legislature, lieutenant governors of other UTs, ex officio members, vice chairman, Niti Ayog, full-time members, Niti Ayog, and union ministers as special invitee. It provides one of the most important forum for deliberations between center and the states and identifying key strategies for cohesive action with the whole of the government approach. Okay, तर ह्या गोष्टींचा जर विचार केला तर लक्षात घ्या या ठिकाणी आपल्याला काय दिसेल. ओके, तर ह्या काय म्हणून नीती आयोग गव्हर्निंग काउन्सिलचं फंक्शन या ठिकाणी लक्षात घ्या. अँड ओके स्टेटमेंट्स हे 1 आणि 2 नंबरचे स्टेटमेंट्स आहेत तर आपल्याला या ठिकाणी चुकीचे दिसून येतात, हे लक्षात घ्या. ओके, ॲज फॉर द एस्टॅब्लिशमेंट ऑफ नीती आयोग इज कन्सर्न, ओके, कन्सिडर हे नोट जे आहे PIBच्या वेबसाईटवर आहे, लक्षात घ्या. द गव्हर्नमेंट हॅज रिप्लेस्ड अ प्लॅनिंग कमिशन विथ अ न्यू इन्स्टिट्यूशन नेम्ड नीती आयोग. ओके, अ कॅबिनेट रिझोल्युशन, ओके, त्या ठिकाणी काय दिलं, पार्लमेंट रिझोल्युशन, ते नाहीये त्याच्यामुळे. अ कॅबिनेट रिझोल्युशन इश्यूड टुडे गिव्ह डिटेल्स ऑफ द न्यू इन्स्टिट्यूशन्स. द इन्स्टिट्यूशन फ्रेमवर्क ऑफ गव्हर्नमेंट हॅज डेव्हलप्ड अँड मॅच्युअर्ड ओव्हर द इयर्स. This has allowed the development of domain expertise, which allows us, okay, the chance to increase the specificity of functions given to the institutions specific to the planning process. There is need to separate as well as energize the distinct progress of governance from strategy of the governance. Okay, lakshat gya. Attempt is to, okay, energize the process, okay, towards the process from the strategy. Okay, and that is the objective of this particular initiative taken by the government. Okay. We'll move to the next question. पुढच्या प्रश्नाकडे जाऊयात आपण. Okay. In the Indian order of precedence, who amongst the following comes first? Okay. Options are former president, chief justice of India, governors of states within the respective states, and speaker of the Lok Sabha. Okay. बघा स्पष्टीकरण बघा. स्पष्टीकरण असं आहे. Okay. As per this particular 1979, okay, updated copy of the table of precedence. Okay, the president comes first, then vice president, then prime minister, and then governors of the state within the respective states, former president, deputy prime minister, chief justice of India. मग या गोष्टी जर विचार केला तर अवेलेबल ऑप्शन्स मध्ये, ओके, C इज द आन्सर. ओके, तर बघा या ठिकाणी C इज द आन्सर. ठीक आहे, येस. बघा, गव्हर्नर, देन फॉर्मर प्रेसिडेंट, देन डेप्युटी PM, and then chief justice of India. Okay, therefore governor is the answer. Next question. Consider the following statement. Election Commission takes decision on assigning the symbol in case of split of a recognized political party. That is true. आपण सध्या हे अनुभवतोय महाराष्ट्राच्या बाबतीमध्ये. That is happening there. And reserved symbol is only allotted to the candidates, okay, set up by the national state or the, okay, state party. Okay, that is also true. Reserved symbol ची ती scheme आहे. And therefore option C is the answer. Okay, पुढचा क्वेश्चन बघा. Consider the following statements regarding office of the deputy prime minister. The office of the deputy prime minister is mentioned in the Indian constitution. Okay, yes, okay, this statement is not correct because you have been asked to identify the incorrect statement, and therefore, okay, this statement is not correct. It is not mentioned in the Indian constitution. The salary and allowances of the deputy prime minister are determined by the parliament. Yes, according to the, what we can say, the salaries and allowances of the ministers are determined by the parliament, and accordingly, okay, the same is true with the, okay, what we can say, deputy prime minister as well. And therefore, the second statement is correct, and the first statement is incorrect, and therefore option A is the answer. Okay, yes. As far as the deputy prime ministers are concerned, okay, these are, okay, deputy prime ministers since the independence. Vallabhbhai Patel, he served as a deputy prime minister during 1947 to 50, and he was the longest serving deputy prime minister. Morarji Desai from 1967 to 1969. Chaudhary Charan Singh 79 to 79, January to July. Jagjeevan Ram from January to July 1979. Yashwantrao Chauhan from July 1979 to January 1980. Okay, then yes. Okay, Chaudhary Devilal from December 1989 to August 1990, and then November 1990 to June 1991, and Lal Krishna Advani from June 2002 to May 2004. Okay, so do remember these points. Okay, this can also be asked. Okay, consider the following statements. The Election Commission has an independent budget finalized directly in consultation between Commission and Finance Ministry. Okay, no. Okay, this is not correct. Okay, this is under Ministry of Law, not the Finance Ministry, Law Ministry. Okay, expenditure for the regular election to the state legislature is shared equally between Union, okay, Union and the state government. Okay. Okay. As per guidelines of the Ministry of Law and Justice issued in October 1979, the entire expenditure on the actual conduct of elections to Lok Sabha is borne by the Government of India. In case of the election to the State Assembly, when they are held independently, the expenditure is borne by the respective state government. But if the elections to Lok Sabha and State Assembly are held simultaneously, then the expenditure is shared equally between Government of India and the state government. Okay. What is this statement? Okay, expenditure for regular, okay, expenditure for regular, that is general election to the state legislature is shared equally between the union and the state government. If it is held simultaneously, okay, then otherwise it is entirely borne by the state government. Okay, then union government bears the entire expenditure related to the capital, equipment and preparation of the electoral roll. Now consider this particular statement. Expenditure is also incurred on other items which are not treated as expenditure for actual conduct of election. Hence, the expenditure on this item has to be borne equally by state and the central government. This includes things like expenditure on regular election establishment and preparation and revision of the electoral rolls. Okay, means what? Okay, the third statement is also incorrect. The first is incorrect. Second is incorrect. Okay, and if we consider that if elections are held simultaneously, okay, then the expenditure is borne by the state and the center. But okay, if the elections are held separately, then it is the state government only. So if we apply this particular argument, then option D, 1, 2 and 3, okay, is correct here, because the second interpretation is held there. Okay, next question. Okay, which of the following statement is or are correct about the state administrative tribunals? Its chairman and members are appointed by the governor of the state concerned. It cannot be established by central government under any circumstances. Administrative Tribunals Act 1985 has a provision for setting up a joint administrative tribunal for 2 or more states. Okay, consider this particular statement. The Administrative Tribunal Act of 1985 gives the Union government the authority to create the state administrative tribunal at the request of respective state governments. The chairman, the vice president, and members are appointed by president after the consultation with the governor of the concerned state. Okay, तर ह्या काय म्हणून आपण त्याला की स्टेटमेंट जर आपण विचार केला तर लक्षात घ्या. ओके, दिस स्टेटमेंट इज इनकरेक्ट. It cannot be established by, okay, it is established by central government. त्याच्यामुळे हे स्टेटमेंट सुद्धा इनकरेक्ट आहे. ओके, आणि त्याच्यानंतर थर्ड स्टेटमेंट मात्र करेक्ट आहे, आणि म्हणून ओके स्टेटमेंट 3 ओनली, दॅट इज ऑप्शन बी या ठिकाणी करेक्ट आहे. ओके, हे लक्षात घ्या. त्याच्यानंतर अंडर विच ऑफ द फॉलोइंग सिच्युएशन्स पार्लमेंट कॅन मेक लॉज ऑन द स्टेट लिस्ट? When Chief Minister of 2 or more states request the Parliament for the same. Okay, Chief Minister असं काही दिलेलं नाही, लक्षात घ्या. When 2 or more states request the Parliament, okay, for the same असं दिलेलं आहे, आणि त्याच्यामुळं पहिलं वाक्य चूक आहे. When राज्यसभा passes a resolution with 2/3 of the member requesting the Parliament for the same, हे बरोबर आहे. For implementation of international treaties, agreements or the convention, हे सुद्धा बरोबर आहे. आणि त्याचबरोबर ओके, जेव्हा नॅशनल इमर्जन्सी असते, लक्षात घ्या, जेव्हा नॅशनल इमर्जन्सी असते आणि ज्या वेळेला प्रेसिडेंट्स रूल असतो, लक्षात घ्या. ओके, नॅशनल इमर्जन्सी आणि प्रेसिडेंट्स रूल, ओके, त्या केसमध्ये सुद्धा हे लागू होतं, आणि त्याच्यामुळे स्टेटमेंट 2 and 3 ओके दिस आर करेक्ट, आणि पहिलं स्टेटमेंट मात्र या ठिकाणी लागू होत नाही. ओके, पुढचा क्वेश्चन बघा आता. ओके, नाउ लेट्स मूव टू 84th क्वेश्चन. 84वा प्रश्न बघा. कन्सिडर द फॉलोइंग स्टेटमेंट्स रिगार्डिंग द नॉर्थ ईस्टर्न झोनल काउन्सिल. इट कन्सिस्ट ऑफ द 8 नॉर्थ ईस्टर्न स्टेट्स इंक्लुडिंग सिक्कीम. हो, हे बरोबर आहे, लक्षात घ्या. इट्स अ करेक्ट स्टेटमेंट. इट वॉज क्रिएटेड बाय सेपरेट ऍक्ट ऑफ पार्लमेंट, दॅट इज ट्रू, बट बाय अमेंडिंग द 6th शेड्यूल, असं काही नाही आहे. ओके, अँड देअरफॉर विच ऑफ द स्टेटमेंट गिवन अबव इज और आर करेक्ट. ओके, द स्टेटमेंट 1 इज ओनली करेक्ट. ओके, इन ऑर्डर टू प्रमोट द कॉपरेशन अमंग द स्टेट्स, वेगवेगळ्या राज्यांमध्ये आपल्याला काय दिसतं की त्या ठिकाणी कॉपरेशन वाढावं, सहकार्य वाढावं, याकरता झोनल काउन्सिलची संकल्पना राबवण्यात आली होती. ओके, पण नॉर्थ ईस्टर्न स्टेटच्या बाबतीमध्ये एक सेपरेट नॉर्थ ईस्टर्न काउन्सिल आहे, कारण इतर राज्यांच्या तुलनेमध्ये नॉर्थ ईस्टर्न स्टेटचे इश्यूज जे आहेत, ओके, ते काहीसे वेगळे आहेत आणि त्यासाठी वेगळ्या कोऑर्डिनेटेड एफर्ट्सची गरज आहे, प्रयत्नांची गरज आहे, आणि त्यामुळे नॉर्थ ईस्टर्न काउन्सिल 1970 मध्ये क्रिएट झाली होती. सो आन्सर शुड बी ओके the one. Okay, yes, consider the following statements. Okay, consider the following statements regarding the office of Attorney General of India. He must have been advocate of some high court for 10 years. Okay, this statement is true. The constitution has provided for the procedure and grounds for his removal. हे नाही आहे. Okay, he holds the office till the pleasure of the president, and म्हणून हे statement चुकीचं आहे. Okay, he receives remuneration, okay, such as president may determine. Okay, हे स्टेटमेंट सुद्धा बरोबर आहे. त्याचं जे remuneration आहे ते प्रेसिडेंट कडून डिटरमाइन केलं जातं. Okay, because he represents the center in different courts. Okay, and therefore, okay, yes, त्याच्यामुळे आपल्याला काय म्हणता येईल या ठिकाणी, या पुढील कॉन्टेक्स्ट मध्ये सेकंड स्टेटमेंट हे रॉंग आहे, पहिलं आणि तिसरं हे बरोबर आहे. चलो, पुढचा क्वेश्चन आहे. Consider the following statement with respect to Union Public Service Commission. Okay, UPSC. 1/2 of the members of the commission should be such persons who have held office for at least 10 years, either under the government of India or the government of the state. The chairman and members of the commission hold office for a term of 6 years or until they attain the age of 65 years, whichever is earlier. The conditions of service of the chairman and other members are determined by the parliament. Okay, so here the conditions of service and chairman and other members are determined not by the parliament but by the president, and therefore the third statement is incorrect. Okay, 1 and 2 are the correct statements. Okay, next question. Which of the following statement is correct regarding National Investigating Agency? The NIA can investigate a terror case in a state only after getting permission from concerned state government. Okay, this statement is not correct. Okay, because in case of terror cases it needed a speedy proceedings, and therefore this statement is wrong one. It has the authority to investigate offenses that are committed outside the Indian territory. Okay, yes, this statement is correct. The agency can investigate offenses related to the cyber terrorism. Okay, this statement is also correct. Okay, the first statement is incorrect because only after getting permission from the concerned state government, this particular statement is wrong. Okay, then 88 number is a question. Consider the following statements with regard to the administrative machinery in India. It is the responsibility of ministers to retain political control over the administration. Okay, हे बरोबर आहे. Okay, it is responsibility of the minister to retain the political control over the administration. हे बरोबर आहे. Its members are political appointees of the government in power. Okay, this is wrong. Okay, this is about administrative machinery, and administrative machinery political appointees त्यांचा समावेश नसणार आहे. Okay, लक्षात घ्या. All civil servants work under supervision of the state governments and can be removed by them. Okay, this is also not correct. Civil servants they supervision, so state government supervision खाली काम करतात, but president can remove, and therefore 2 and 3 are wrong. Okay, and statement 1 should be correct here. Yes, statement 1 should be correct. A. Then next question. Okay, consider the following statements with reference to Directorate of Enforcement. It works under administrative control of Department of Revenue, Ministry of Finance. Okay, हे बरोबर आहे, लक्षात घ्या. Okay, it is responsible for investigating offenses under Prevention of Money Laundering Act 2022 इथं 2002 असायला पाहिजे होता. Its director is appointed on the recommendation of a committee chaired by the Central Vigilance Commission. Okay, which of the statements are correct? This is the question. Okay, consider this particular explanation. ओके, द ईडी डायरेक्टर, ओके, बघा या ठिकाणी काय सांगितलेलं आहे, ईडी डायरेक्टर इज अपॉइंटेड बाय द सेंट्रल गव्हर्नमेंट ऑन द रिकमेंडेशन ऑफ कमिटी चेअर्ड बाय द सेंट्रल विजिलन्स कमिशनर, ओके, and members comprising of vigilance commissioners, home secretary, secretary DOPT and revenue secretary. ओके, आणि त्यामुळं हे तीनही स्टेटमेंट हे बरोबर लक्षात घ्या. ओके, यस, त्या ठिकाणी 2002 असायला पाहिजे, इट वॉज अ प्रिंट मिस्टेक. यस, नेक्स्ट क्वेश्चन, 19 नंबरचा क्वेश्चन. Which one of the following statement is correct about the administration of the scheduled area? The governor is empowered to declare an area to be the scheduled area. Okay, no. Okay, this authority is given to the president. Okay, the 6th schedule of the constitution apply to the administration of the scheduled areas. Okay, no. 5th schedule is there. The executive power of a state does not extend to the scheduled areas. Okay, therein the executive power of the state extends to the scheduled areas therein. In the administration of the scheduled areas, both center and state have duties to play. The center gives the state instructions on how to administer these areas. आणि त्याच्यामुळं ओके लक्षात घ्या, हे स्टेटमेंट चूक आहे, हे स्टेटमेंट चूक आहे. The governor is empowered to direct that, okay, any particular act of parliament does not apply to, okay, the scheduled area. Okay, this statement is also a wrong one. The governor is empowered to direct that any particular act of the parliament or state government does not apply to scheduled areas, or if applied, then with specific modifications and exceptions. And therefore, the option D is the correct one. D हे बरोबर आहे. Okay, चला next point, next question. Which state launched the Mukhyamantri Mitan Yojana? It is Chhattisgarh, to deliver the civil services at doorstep. ज्या काही नागरी सेवा असतात लक्षात घ्या, त्या घरापर्यंत पोहोचवण्यासाठी म्हणून छत्तीसगडनं हा उपक्रम सुरू केलेला आहे. ओके, नेक्स्ट क्वेश्चन. Alagille, okay, syndrome, which was seen in the news, is associated with which part of the body? It is liver. Okay, this particular syndrome is an inherited condition in which bile builds up in the liver because there are too few bile ducts to drain the bile. Okay, this results in the liver damage. Okay, till date it was considered as an irreparable disease, म्हणजे दुरुस्त न होण्यासारखा होता. But recently there are, what we can say, there is a news that the drug is getting discovered. Okay, drug is being discovered and it is in process. आणि मग हे जर झालं तर हा एक दुर्धर अशा प्रकारचा जो आजार आहे तो ओके बरा होऊ शकतो. अँड देअरफॉर इट वॉज इन द न्यूज. ओके, यस. नेक्स्ट क्वेश्चन. द सावा लेक, अ बायोडायव्हर्सिटी वेटलँड सीन इन द न्यूज, इज लोकेटेड इन विच कंट्री? इट इज इन द इराक. अँड व्हाय इट वॉज इन न्यूज? कशामुळे न्यूज मध्ये होती लक्षात घ्या. ओके, हे तलाव, the Sawa Lake, a biodiverse wetland situated near the city of Samawa, south of the capital Baghdad, has disappeared largely due to the human activity and climate change. Okay, तर हे disappear झालेलं आहे human activity मुळे आणि त्याच्यामुळे हे न्यूज मध्ये होतं, लक्षात घ्या. ओके, पुढचा क्वेश्चन आहे. कन्सिडर द फॉलोइंग स्टेटमेंट्स विथ रेफरन्स टू लेव्हेंडर रिव्होल्यूशन. ओके, लेव्हेंडर रिव्होल्यूशन रिसेंटली, ओके, लक्षात घ्या की पर्पल रिव्होल्यूशन किंवा लेव्हेंडर रिव्होल्यूशनची संकल्पना आपल्या स्टेट गव्हर्नमेंटनी मांडलेली आहे. इट एम्स टू सपोर्ट इंडिजिनस अरोमॅटिक क्रॉप बेस्ड अॅग्रो इकॉनॉमी बाय मुव्हिंग फ्रॉम इम्पोर्टेड अरोमॅटिक ऑइल्स टू होम ग्रोन व्हरायटीज. ओके, हे बरोबर लक्षात घ्या. ओके, हे स्टेटमेंट बरोबर, दिस वन इज करेक्ट. हायड्रोसोल which separates from lavender oil is used to make incense stick. उदबत्त्या बनवण्यासाठी हायड्रोसोल वापरलं जातं. ओके, and third statement is lavender water which is formed after distillation from the flowers is used to make soaps and room fresheners. हे स्टेटमेंट ऍक्च्युअली काय झालेलं आहे? हायड्रोसोल and lavender water, this is basically shuffled and therefore the second statement is wrong, third statement is wrong, the first statement is correct. Okay, incorrect statement विचारलेलं आहे. 2 and 3 are the incorrect statement. Okay, next. Okay, consider the following statement regarding digital India Bhashini. Bhashini stands for Bhasha Interface of India. Yes, that is true. Digital India Bhashini and India's artificial intelligence AI-led language translation platform will enable massive citizen engagement. Okay, that is the core point of this particular initiative. The citizen engagement to build multi-language datasets through a crowdsourcing initiative called Bhasha Dana. So citizens ते काय करायचं? ओके, त्याची vocab आहे. ओके, जे काही भाषेचे शब्दांचे जे सेट्स आहेत, ओके, लक्षात घ्या, त्यामध्ये कॉन्ट्रीब्यूट करायचं. अँड इव्हेंच्युअली इट वुड बी स्क्रुटिनाइज्ड अँड इट वुड बी मेड द पार्ट ऑफ द रिपोजिटरी देअर. ओके, आणि हा त्याच्या मागचा हेतू आहे. It is an artificial intelligence-led language translation program, a platform under the Ministry of IT and Electronics, MeitY आपण ज्याला म्हणतो. Bhashini platform is a part of National Language Translation Mission. That is also true. So all 1, 2 and 3, these statements are correct. Okay. Yes. Next question. KBIC chairman Vinay Kumar Saxena has been appointed as Lieutenant Governor, okay, of the, okay, yes, New Delhi, because he was in news right now. Simple fact आहे, नवी दिल्लीचे चेअरमन म्हणून त्यांची अपॉइंटमेंट, लेफ्टनंट गव्हर्नर म्हणून अपॉइंट झालेली आहे. In which state or the UT, North India's first industrial biotech park was inaugurated? जम्मू अँड काश्मीर मध्ये कथुआ नावाची एक जागा आहे आणि त्या ठिकाणी हा इंडस्ट्रियल बायोटेक पार्क हा इनॉग्रेट करण्यात आलेला आहे, लॉन्च करण्यात आलेला आहे. ओके, सिंपल पार्ट ऑफ द करंट अफेअर्स. ओके, next question, which state has formed an expert committee for implementation of uniform civil code? Uttarakhand is the answer. Recently Uttarakhand has formed this particular expert committee and it is seeking opinion from the people of that particular state and okay, how that particular uniform civil code should be implemented, what mechanism has to be brought up. Okay, त्याच्यामुळे सध्या न्यूज मध्ये होतं. With reference to the Pradhan Mantri Jan Arogya Yojana, consider the following statements. It provides for primary, secondary and tertiary care hospitalization. Okay, is this statement correct? Okay, because this particular scheme as it is provided, okay, PM, okay, Pradhan Mantri Jan Arogya Yojana is the world's largest health assurance scheme, aims to providing health cover of rupees 5 lakh per family per year for secondary and tertiary care. Okay, but here it's at a primary care as well and म्हणून हे statement चुकीचं आहे. It covers both pre-hospitalization and post-hospitalization expenses. Okay, that is true. And there is no restriction on the family, size, age or gender per family per year. And therefore, there are no restrictions. So, second is correct, the third is correct and answer, okay, B. 2 and 3 is the answer. And now, we shall discuss the next and the last question. Okay. Regarding Thomas Cup, consider the following statement. It is related to the field of tennis. Okay, no. It is related to the field of badminton. Okay, Thomas Cup सध्या न्यूज मध्ये होता, भारताने बऱ्याच दिवसांतर जिंकलेला आहे. Okay, badminton, and therefore the first statement is wrong. The first tournament was won by the Malaya. Okay, हे सुद्धा बरोबर लक्षात घ्या. Okay, first tournament जी होती ती मलायाने जिंकलेली होती and India becomes 6th country to win this cup. Okay, second and third, okay, this statement are also correct. India had never reached the final of the Thomas and the Uber Cup in the tournament's 73-year okay, long history. But Indian men not only broke the draft but went a step ahead and became only the 6th nation after China, Indonesia, Japan, Denmark, and Malaysia to win the Thomas Cup title. Lakshya Sen, okay, then okay, Satvik Sairaj, okay, and then Chirag Shetty, Kidambi Shrikant made it for the historic victory. Okay, remember these names. UPSC विचारते ना व्यक्तीच नाव देऊन, okay, this particular person associated with which among the following field, music असेल किंवा sports असेल, अशा प्रकारचे प्रश्न विचारले जातात. So we have win, okay, that particular cup, Thomas Cup, and therefore, okay, this became the part of this question paper. Yes. Okay, so thus we have covered this particular test, 100 questions. Hopefully, okay, we have discussed several nuances, the deeper nuances of the each and every question. Hopefully, okay, you liked it. Thank you very much for attending this particular session. Okay, I wish you all the best. Thank you.